Well, hello everyone, and welcome back to Uncivil Law, where we learn through the misfortunes of others. I'm your host, Uncivil Law, a licensed attorney in Texas, Virginia, and before the United States Supreme Court. And I hope today is the day I earn that subscription. For today's afternoon video, our continuing coverage of the Scot Peterson trial. Well, my friends, we heard from the state's closing, which was essentially technical perfection. 9.9 out of 10. Trying to find errors was like, pullings at hen's teeth, kind of difficult. And then we heard from the defense's closing, which was disorganized, confused, chaotic, lackluster, and had some good points in there, but overall problematic. And don't worry, friends, if you want to really hear more from the defense lawyer, I've got good news for you. Do you want to hear more from the defense lawyer? I know you did. I know 2 hours was just not enough for you. Well, good news, friends, because the defense lawyer has asked for the ability to proffer the portion of the closing argument he wasn't allowed to give. Exciting. So after the state gives its rebuttal, and after the jury is charged and sent to deliberate, we get to hear another 20 minutes from defense lawyer speaking to no one in particular as he proffers what he would have argued in his close had he been allowed to. Exciting. So we get to another 20 minutes-ish of defense lawyer talking for those of you who are just craving more defense lawyer. I know you're thrilled. I'm thrilled too. And he says 20 minutes, but of course at that point, he's off the clock, so it will be as long as it will be. He's like, I want more time now. The judge's like, he said, I don't think you're making good use of your time. So yeah, I've never heard of a proffered closing argument. This is a first. Proffered witnesses, sure. Proffered closing argument, I don't know. And you weren't able to get done in 2 hours, really? So for those of you who enjoyed the previous plane crash, the airline is taking off again. Don't worry, we'll get it right this time. We've learned from our mistakes. Trust us. Did I change my opinion on the SRO being a caregiver? No, not personally, no. I don't think so. Because you read the language of the statute in context. So when it says, what is the exact language here so I can get it verbatim? Hold on. Let's see. Child. What is the exact language? Okay. But what, yeah. Okay. Caregiver under Florida law is defined as parent, adult household member, or other person responsible for the child's welfare. So when you have the and other stuff clause, right? When you have the and other stuff clause, there's a maximum law that we interpret the and other stuff as being like the things that came before it. So it's in mentis mundus, I think. What is the actual Latin? Latin interpretation in context. Law. Let's see if I can find the exact Latin expression. Etsum generis. Etsum generis. Latin phrase meaning of the same kind. So yeah. So I'll put it on screen because we've got a moment. Well, give me a second. I'll get there. Give me a second. All right, I'll get there. One thing at a time, guys. All right, I'll talk about teachers in a second. All right, so there's this principle of statutory construction et sum generis of the same kind. It's a statutory and constitutional construction principle, states that where general words and other stuff or phrases follow specific words, the general words are specifically construed as limited and applied only to the things of the same kind or class as those expressly mentioned. For example, if a law refers to automobiles, trucks, tractors, motorcycles, and other motor powered vehicles, a court might use this principle to hold that such vehicles will not include airplanes because the list only includes land-based transportation. So this is like a general understood principle of construction, right? Of the same kind. So when you have specific stuff followed by the and other stuff is understood in the context of the specific stuff. So if you move to the definition, which I will find in a second, which is defined somewhere. Definitions for HCI. Okay, yeah, so here we go. So if we move to the definitions section in Florida law, caregiver means parent, adult household member, or other person responsible for a child's welfare. So other person should be interpreted in the vein of parent or adult household member. Now, as to teachers, there's this idea of in loco parentis, right? There's this very old doctrine when it comes to teachers and the school of in loco parentis, in the place of parents or in the substitution of parents, is a very, very old doctrine that gives the school parent-like authority over the children in their care. And if you go old school enough on this doctrine, that really applied even more, right? So the idea of in loco parentis was, if you go old school, the teachers were parents essentially. For there's no legal distinguishment basically. So if you go old school on this concept about parents and teachers, right, they would be able to do literally anything a parent could do. Right now, that has been somewhat mollified in more recent jurisprudence, so it's not quite as wide as it was. But when it comes to teachers and the school, you have this idea of in loco parentis. They're acting in the stead of the parent, so they are, to some legal degree, the parent. So because they are in loco parentis, therefore they are the parent, therefore they fall under the definition of this as a teacher or the school because of this old school doctrine, which has been mollified and moderated, but not completely abolished. So as to law enforcement officials, that doesn't work, right? There is no similar doctrine. There's no similar doctrine where police officers have been understood historically in loco parentis. That is not a relevant concept. So, and also the state as a whole doesn't really have in loco parentis over its citizens, which incidentally states have tried to varying degrees, but not really, not so much. So, can you interpret a teacher as being a parent? Yes, under the doctrine of in loco parentis, you can get there. For a school resource officer, not so much. So I don't think they are a parent, adult household member, or someone who was akin to that. You know, like a babysitter maybe is like a parent or adult household member. So would a babysitter qualify? Well, they're substituting in the home in the scenario, right? They're substituting in the home for the parent. They are not the parent. They're not an adult household member, but they are substituting for that role. So probably close enough for a babysitter, but not for a parent. And that's where I break down on the legal assessment and where I think this charge breaks down legally. So hopefully that makes some sense. That makes some sense. And he's not an employee of the school. He's not an employee of the school or the school district. He's a sheriff's officer. So the idea of in loco parentis doesn't really work. So I don't think it works legally. Yeah. If the school resource officer is paid through the school district, does it matter? Not really. First of all, I don't think that's true that he's paid through the school district, but even if he is, who pays you and who you're in the employ of can be legally distinct. And that concept applies most notably to lawyers specifically, by the way. A lawyer's duty is to the client regardless of who is paying the lawyer. So at least in the legal profession, we separate those concepts very cleanly. Can I accept money from someone other than the client? Yes, if the client consents to it and knows about it, sure. But the person who's paying me has to understand that they're not the client. The client is the client. So they can pay me, but they have zero control over the case. So who's paying him and who's in the employ of, I think, are different. So is he being paid by the school? I don't think that's true. And even if true, I'm not sure it's the positive. So, but all that being said, yeah, the Court of Appeals of the 11th Circuit upheld by lower court police could not be held liable for a shooting. Yes, in civil court, that's true. That's a 42 USC. Yeah, you guys are overreading all these cases, and I don't blame you for overreading it. It is a problem apparently among lawyers, right? But at least in my humble opinion, you guys are overreading a lot of these cases. Yes, there's a shit ton of cases, as we pointed out, both from circuit courts and the U.S. Supreme Court, that speak to an officer's liability in a civil context. And when you talk about the 11th Circuit, you're talking about federal law, right? You're typically talking about 42 USC 1983, because that's typically why we're in federal court, right? So is there liability, civil liability under 42 USC 1983 for failure to act? No, not typically, no. Although some exceptions may apply, but those exceptions don't appear to be prudent here. So those civil cases, I really don't think speak to that issue. That's why it hasn't come up. Yeah. So I don't think there's really anything for the federal courts to do here, at least as far as I can see it. I don't think there's anything for the federal courts to do here. There's no federal issues at stake. I don't see a federal court getting involved in this decision. This is probably going to stop at the Florida Supreme Court.
Essentially, that juror participated in penalty phase, showed up to the courtroom. It knows the victim advocates by name from our office, and approached her in public, gave her big.
What's going on now?
Today, during lunch. So,
What number is that juror?
I don't recall her number.
We have a problem with the juror? Uh-oh.
Well, let me go sidebar real quick.
Let me listen to that back.
I spoke to there's actually last name.
And conclude with your rebuttal argument.
Yes, Judge. So it has come to our attention that one of the jurors had an interaction with one of our victim advocates from the state, and they let us know about that interaction. But then when I asked how the two knew each other, there's actually a lot more involvement that juror had in the Parkland case than I believe was led on to either myself or Mr. Eiglarsh. I spoke to Mr. Eiglarsh about it. Essentially, that juror participated in penalty phase, showed up to the courtroom. It knows the victim advocates by name from our office, and approached her in public, gave her a big hug. During lunch. So.
What number is that juror?
I don't recall her number. It might be 3.
Well, let me go sidebar real quick.
Talked about how she had no connection to the case, and it was.
Okay, so we're talking about juror number 3. Defense, do you have any request as it relates to juror number 3 based on this?
Yes, Judge. In light of the announcement, and I'm extremely grateful for the state disclosing that immediately, this was a
Just ask to dismiss the juror.
That I spent considerable time on, even saying, listen, you're a victim rights advocate, and I have concerns about letting you on this jury. Convince
Just ask to dismiss the jury. Just ask to dismiss it. Why are you giving a speech? Your Honor, we move to dismiss the juror. That's all you have to say. Just say the words.
And there is a
God damn it.
significant question as to whether she can be fair and impartial, whether she withheld.
Just say the words. God damn it, just say the
I
words.
appreciate the state not opposing our request to have her removed and the alternate.
There's a lot of words
So
for
if I
we move to
grant that
dismiss the
request,
juror.
Juror number 3 would be out, and then that would move juror number 7 in as the last juror. Is that what you want me to do?
Yes, Your Honor.
All right. State any objection to that?
No, Judge.
Okay, so right now, the jury consists of juror number 1, juror number 2, 4, 5, 6, and 7. The alternates remain 8, 9, and 10. Juror number 3, I'll grant the defense request to excuse her for cause, but I'll just keep her here and then dismiss her with the alternates at the conclusion of the arguments today, barring something else. State any objection to proceeding in that manner.
No, Judge.
Defense, any objection to proceeding in that?
No, Your Honor.
State you're otherwise ready to proceed?
Yes, Your Honor.
Mr. Kilran, are you going to require the TV screens to be on or off during the
it's fine.
rebuttal?
So apparently juror number 3,
Everything stays on.
Yes, Judge, yes.
apparently juror number 3 over here was testified as a victim impact witness in the Cruz trial, the underlying criminal trial, and testified apparently about being a victim of the shooter, and also apparently hugged the victim's right advocate in the courtroom or something during the break. So we think juror number 3 might be a little bit biased over here. Holy shit. Holy shit, dude. Wow. And apparently they're just now figuring this out. Holy God. Wow. Well, it's going great over here in the trial. I hope Law and Crime has enjoyed this one. Holy shit. Hey, Law and Crime, are you having a good time? Let's go check in on Law and Crime and see how they're coping. Uh-oh. Danger, Will Robinson, danger. Sounds like the juror was the victim's right advocate. Yeah, that was a little bit confusing. I don't know if the juror was the victim's right advocate in the underlying trial, or if they also happened to be a victim's right advocate themselves. I don't think they were the victim's right advocate in the case, although I could have misunderstood it. But my understanding is they are a victim's right advocate, but not the victim's right advocate in that particular case. My understanding was that they were testifying as a victim impact, I think, was what I distilled from that. But either way, they had a little bit of impact with the case. Yeah.
Jurors entering.
Yeah. It's a 6-member jury. It's a 6-member jury. Florida uses 6-member juries in non-capital cases.
Ladies
That's
and
how
gentlemen,
Florida
welcome back.
rolls.
Come on in. You all may be seated. All the parties may be seated. Ladies and gentlemen, those of you using the notepads, I'll give you a moment to get the notepads back out. All right, ladies and gentlemen, welcome back. I hope you had a nice lunch break. Before the lunch break, we had heard the state's closing argument as well as the defense closing argument. All that remains is the state's rebuttal argument, which we are going to proceed with at this time. Mr. Killen, when you are ready, you may proceed.
Thank you, Judge.
So juror number 3 is still sitting there in the box because the judge is like, I'm not going to dismiss until I send the jury back. So juror number 3 has to listen to all this, even though they're not going back. So we have to break the bad news to juror number 3.
Just like you guys have for the last month or so. The thought that keeps popping up is just do it. Just do something. Just do anything. You're trained, as you heard from Lieutenant Colonel Samaru.
Thank you,
Your
Sandra,
mere
for the gift
presence
memberships.
As an officer,
Holy shit,
stop
dude.
an active shooter. Your mere presence there will throw them off their plan. And in this case, Cruz's plan was to kill as many people as possible. Looking in the window, opening up the door. Opening up the door, you would have smelled the gunpowder, just as officers have testified. You would have seen the carnage. You would have had that information. That information that Scot Peterson chose not to gather. Instead, he chose to run away 75 feet from the building. I want you to think back, and I'm not going to show you all the videos because, frankly, I only have an hour, but I want you to think back to that video of all those children during the fire alarm coming out of the 700 building. And when shots are fired, and we heard from a whole bunch of them, when loud noises were heard, what did they do? They instinctively ran away from the 1200 building. The same building that Scot Peterson was outside of for 48 minutes. 48 minutes. You know, I downloaded a timer on my clock to play for you guys during my closing of 48 minutes where he stood in his fixed position. I decided not to go that route.
Oh, thank God.
The defense said that the defendant had no clue where the shots were coming from. If that were true, he wouldn't have stayed where he was for 48 minutes. Where he saw, as I was saying before, those kids come out of the 700 building and run instinctively back. But what didn't you see? What didn't you hear about? Any kids coming out of the 1200 building at the same time. So we asked you in jury selection to use your common sense. Common sense dictates that if hundreds of kids are pouring out of the 700 building because of a fire alarm, and not one kid is coming out of the east side doors of the 1200 building, something's wrong in the 1200 building. And what did Mr. Peterson choose to do? Run away. 75 feet. Didn't open the door, didn't look in the windows, didn't go BSO. Didn't take out his gun and shoot it into the ground. Something, anything to show his presence, his mere presence in the building, to throw off the killer from shooting innocent children. He had a Glock on his hip that day. Those kids on the third floor had pencils. They were about as helpless.
I once saw him kill 3
as an
people in a
infant.
bar with a
And what did the
pencil.
guy who calls them my kids do? He ran away. Because if those were actually his kids, let me tell you something. I don't think he would have ran away. I don't think he would have stayed in a fixed position for 48 minutes if those were actually my kids. You heard from the cop yesterday, whatever his name was, Perry. You heard him say, they're not my kids. They're not my school. That's a caregiver, because an SRO is a caregiver, who doesn't care. And you want to know who another SRO who was a caregiver back on February 14th of 2018 who didn't care? Scot Peterson.
Nice.
He chose his own life over every single person in that building. Those kids on the third floor, those teachers on the third floor, Mr. Beagle, he chose his life, even though he had this vast training. All of this evidence you get to take into the jury room, and you can look at anything you want. This yellow folder right here, which is States 13, is his training. This is the logs beginning in 99, and remember, he was a cop about a decade earlier. This is all of the training he had. He was an SRO basically his entire career. This is what he was trained to handle. And when the shots started, what did he do? He ran away. Now, this is the part of the closing that's called the rebut. And what does that mean?
Yes.
That means I get to rebut, try to convince you that what the defense attorney said before lunch is incorrect, and explain why. Now, this is an interesting rebuttal, because while I'm going to talk about what the defense attorney spoke about, I'm first going to talk about what he didn't talk about, which is, Judge, if I could use the arm, please. The elements of the crime. Ladies and gentlemen, this is why you've been here for 4 weeks, to see whether the state can prove beyond a reasonable doubt these elements.
Yeah.
Ms. Gomes, in her opening, went thoroughly through all of the elements, and I'm going to touch
She
on
sure
this very
did.
briefly. Defense didn't mention it. They talked their fantasy story about what this and the football fields and all this. The state called witnesses to prove elements,
The defendant's so fucked, guys. The defendant's totally fucked.
to talk about
Game over, people. Game over.
because we have to prove an element. We had the stipulation signed to show that the kids were under the age of 18. Why? Because we had to. We had to. These were
My fish was good, thank you.
not even mentioned. Now,
Could have
what
used some
the
tartar
defense did
sauce
say
though,
is,
but otherwise
the state
fine.
needs to prove everything beyond reasonable doubt. That's not true.
I also could have used some tomato or something. Made a sandwich out of it. That would have been nice. It was a little dry by itself, but you know,
And I'm not going to read them through. You can read them yourself. You're going to get a copy when you go back to the jury room. Those are the 4 things that we need to prove for each person under the age of 18. For culpable negligence, these are the 2 that we have to prove beyond a reasonable doubt. Nowhere in there are you going to hear we need to prove that he knew precisely where the shots were. We don't need to prove that. Now, we can certainly show it, and that's going to be the next part of my rebuttal, but we don't need to prove it. We only need to prove this checklist, as you saw Ms. Gomes check off the elements. That's our entire job. And when the defense gets up here and says it's a 5-minute not guilty, we're not looking at the elements, ladies and gentlemen. When I'm done and I sit down, you're going to hear the jury instructions. And part of your job, as you swore when you took the oath to be a juror, is you're going to follow
Oh,
the
he's so
instructions.
fucked.
Let me tell you, those instructions are a lot. If you can read them in 5 minutes, God bless you. But you all held up your hand. You all said that you will follow the law. This is the law. This is the law for culpable negligence. This is the law for perjury.
So, Mr. Peterson, what kind of prison cell would you like?
That he didn't do anything.
We've got a nice window-facing one.
Hot seat with Curcio.
We got an interior one that's a little quieter.
Because he was the first.
Maybe would you like some
officer.
protective
He
custody?
needed to get information.
Do you want a
from him
kosher meal?
for his investigation into Nicholas Cruz?
Holy shit, dude.
Defense asked, well, why would he lie? He lied because he didn't do anything. He lied because he had a responsibility as a caregiver to those kids to do something, and he didn't. Now, although it's not an element, I'm going to talk.
Would you like a prison by the
concept.
seaside, or would you like
How the
one in the
defendant
mountains? Although it's Florida. Florida doesn't have mountains. So
Well,
I
let's
guess
start
it's
off
out.
with the fact that campus monitor Medina, whose only job is to observe and report, calls over suspicious person into the 1200. Now, to believe the defense, he didn't hear that radio. Just like his friend who helped him move, or not his friend, Arthur Perry, said, oh, he conveniently didn't hear pertinent calls either. But he didn't hear that. Suspicious kid in 1200. Firecrackers. Yet when he gets in with the cart with Medina, he gets dropped off where? The 1200 building. And if you remember Kelvin Greenlee's testimony, when asked, was it possible there was a conversation between Peterson and Medina, he said it was possible. He didn't hear it. Watch the video. He's riding on the back like Batman, going up to the 1200 building, where he hears noises, but he still continues on the way, even though he's an unarmed security specialist. Now, dropped off at the 1200 building. Then we can talk about the dispatch calls. And you can hear them. They're in evidence. How many times does Scot Peterson say 1200 building? By inside, near, he's saying the 1200 building. That is the building he is describing repeatedly. That is the building where the kids ran from, that he saw, back to the 700 building. That's the building that he, according to some of the defense witnesses, he's crouched pointing at. You heard from all the witnesses, he's scanning the area to the west, which, by the way, just happens to be where Nicholas Cruz ran out by himself minutes after any other kid came out. And he's the only one that ran that direction, but you guys can check out the videos for yourself. And looking to the north, where the 5 kids ran out. Now I had this whole elaborate plan in rebuttal to show all you guys these videos, but you've been sitting here 4 weeks, you've seen the videos, and frankly, you have access to the videos in the back. But when you watch that video, and it's F12, I want you to notice something about one of those 5 kids running out. She has a balloon in her hand. It's Valentine's Day. When she's running out of the building, she doesn't drop the balloon. She's a kid. She runs with her balloon. So the defense to say that because of a couple pipes and a fence and a pillar, he can't see her, that is what they call malarkey. Okay? She has a balloon in her hand. He's had the strategic vantage point, according to the defense, to see her. And he conveniently doesn't see her. Because what would that be? Hey, where's the shooter? But if he asks that, guess what? He's got to go in. So it's not asked. Let's just presume something here. And this isn't reality, but just bear with me. Let's just say the state put no witnesses. We just put on the dispatch tape. We just put on the dispatch tape, and we just put in the statement that Peterson gave to Detective Curcio. Even those alone, just those 2, would show he knew it was the 1200 building. Listen to the dispatch.
Dude, you can shake all your head all you want, baby, but you're going to prison. You're going to jail, baby.
Building, he mentions the entire
Dead man walking.
Judge, objection, misstatement of the facts.
The
Overruled.
objection's overruled. Again, ladies and gentlemen, you all will determine what the facts of the case are. Go ahead, sir.
And what was his job, knowing that it's in the 1200? As Ms. Gomes said, on the
Oh,
first
you're so
part,
fucked.
it wasn't to engage in a firefight. It wasn't to get into a gun battle. It was to make his mere presence known, to mess up the shooter's OODA loop. And that's what goes through, I guess, shooters' minds when they're trying to kill innocent children. And yet he chose not to do that. And let's just presume, based upon the defendant's statement, although you can hear in the back of the dispatch other shots are being fired, let's just presume 2 or 3 shots. So you have reports of firecrackers from the 1200 building, and you hear 2 to 3 shots from a building you ran away from. What does the training say to do? What does common sense say to do? What does the fact that you're a police officer say you do? You go and investigate. You don't go back and play on the radio for 48 minutes. You go and gather intelligence. You go and do your job. And he didn't do that. And that's if you consider just the dispatch and just the statement. Yet the state has shown so much more. You heard from the 2 people standing near the defendant, Mr. Greenleaf and Mr. Stoneman, that they knew instantly 1200 building. Stop waiting inside 1200 building. Those are the two that have the same perception, the same vantage point as the defendant. The kids called running out of the 700, different vantage point, different perspective. The cops up on Holmberg Road, who, by the way, were told to stay back.
I don't know why the defendant has such a
Peterson,
smug smile on his
they're
face.
100 yards plus
I have a smile
away.
on my face
They're
because
there for mere seconds during
it's so
the shooting.
ridiculous how bad this league's
He's
going.
there for 4 minutes and 15 seconds.
I don't know why he has a smile on his
He
face.
hears 70 rounds. This is states 48. You heard from Detective Crespo. This is just a mere sample of the shell casings, where he has the audacity to say here 2 to 3. You heard those videos from Danielle Gilbert and Ivy Seamus, the first two witnesses in this case. And once again, I'm not going to play the videos for you right now, but you can take them in the back and listen to them yourself. How loud. This sounds like artillery shells. Yet he says 2 to 3 shots. Defense
Sound like
keeps saying
artillery shells?
that he had to know precisely.
Artillery shells are quite a bit louder.
That's just simply not true. That's not what the training says. Why do you seek out a shooter? To find the shooter. And let's be honest, after you heard from Lieutenant Cardinale about what classroom his son was in, he didn't know the different classrooms anyway, even though he's been the SRO there 9 years. His job was to go investigate and make his presence known, and that simply did not happen.
Luca, he's facing 95 years plus loss of pension.
Now, one of the very important
Yeah.
intricacies in this case is in regards to training. And it's in regards to when shots are being fired versus after shots are being fired. When shots are being fired, there is one and only one priority, and that is to seek out the sounds
I don't like the
of
badge
shots.
hanging from his belt.
Whether
Look,
the
that
person
kind of looks
barricades
sloppy and
themselves,
with the suit.
kills themselves, flees. Your job
And what's with
only
those
job
shoes?
is to go seek out that shooter. It's not to put down or lock down the intersection on Holmberg. That's a secondary thing. You are to go in. Now, after the shots are over, you're trained to look for additional stimuli. You're taught to investigate as a police officer. You look for things such as blood, such as bodies, as callous as that sounds, such as smoke, such as shells on the ground, maybe, like 130 of them. You're trained to look in windows. As the defense witness Goolsby said when he got to the 1300 building, he looked in the windows. That's what you're supposed to do. You're supposed to be proactive. Even Stambaugh, who got on scene, and someone called out that they needed overwatch, and he drove around the sawgrass. Even he was proactive. Literally every cop, even Perry, who I couldn't get a truthful answer out of, did something. He scanned the area. He did nothing. So much so that even when it's all over, he doesn't go inside to help with the rescue efforts, to help with the medical treatment. You saw the records, you heard about it. Rescue task force after a shooting's over.
I object to those shoes.
Every shot that you hear could be another dead body, and you need to stop the bleeding. He doesn't go in. Once again, it's not an element we have to prove, but it's
I
just
think his
common
cough
sense.
is a little long on the
He
suit.
did jack. He did nothing. So he didn't go in. Why? To see the carnage, especially on the 3rd floor, that he allowed to have happen because he chose his own life over students in the freshman building, over 14, 15, 16-year-olds, over Meadow Pollock, who just turned 18, over Scott Beagle. defense went through all of the witnesses, and they asked some questions. Why were they called? I'm going to go over the state witnesses, just very briefly, I promise. First witness, Ms. Gilbert. Defense says, didn't show anything having to do with this case. I actually could not disagree more if you paid me. Because through her,
You are getting paid.
you heard how loud that cannon was. That's how loud it was. That's not made up. That's not CGI. That's not audio from Hollywood. That was real life, how loud that was. Once again, feel free to listen to it. Same with the second witness, Ivy Seamus, her video. How loud that gun is on the inside. It's ridiculous how loud it is. That's why they were called. Heinrich. Heinrich is watering the baseball field. He hears firecrackers, draws his attention. What does he do? He runs, unarmed, wearing basketball shorts to the building. Unarmed, no vest, nothing. His son goes to that school. He has kids. He knows something's wrong. Does not hesitate. Comes across Elliot Honor, Vietnam vet. Shot a gun for 3 years in Vietnam. Reversing, saying Feist is down. Does Heinrich turn around? He's not a caregiver for them. He has no obligation to those kids. Zero. Does he turn around? No. He keeps going forward, unarmed. And what does he do? He sees Kyle, and you heard from Kyle, and you saw that poor kid's leg. And what does he do? He helps Kyle, because according to Jeff Heinrich, that's a catastrophic injury. That means that kid can die from that injury. And he provides treatment. And you heard him, he brings him along the fence, ultimately over to the dugout, to the office. Now, on their argument, they said Heinrich heard every single shot. I think they're forgetting that Heinrich went around and was in the baseball office, but I digress. The defense said he took a tactical position of cover. Yeah, for a couple seconds. And then even unarmed, he still had action, made action. And frankly, saved Kyle's life. Ryan Stobley. Ryan Stobley was a security monitor. You see Ryan Stobley on video. Once again, I'm not going to show it to you. You can watch in the back. While the shooting's going on, he, because of his concern to protect these kids, walks out. And you can actually see him. Once again, it's on F13. You can see Stobley because he sees kids in the parking lot, and he's waving them away. His concern is not for himself hiding. His concern is to try to help those kids. And what does he say? He says, shots from inside the 1200 building. Then you heard from Kyle. Why was Kyle called? Because Kyle's a victim in this case. And to prove the elements, we need to show the victims, the survivors. That's why Kyle was called. But not only for that reason. You also heard testimony from Kyle that as he's bleeding, and Jeff Heinrich helps him because when he goes outside, he's asking, I need an adult. Because the only adult on campus who's armed didn't do anything. But as he's making his way up, he continues to hear shots, how loud they are. That's the testimony of Kyle. Then you heard from Ed Suarez, who's the head of maintenance. This is a man who drove all the way up, and even when shots are fired behind him, and he testified he knew the shots were coming behind him, he was still ushering and protecting those kids. He did not need to do that. He chose to do that because those students are vulnerable. They're children, they're babies, they're kids. You heard from Anthony Borges. You heard about his terrible injuries. You heard that he's on the ground for 40 minutes bleeding out. And it just so happens that the one adult armed on scene is telling the other armed adults to lock down the intersection and stay back 500 feet. That kid called his dad to say goodbye. as he's bleeding out on the ground. Screaming out in Spanish and English, help, help. And where was help? 75 feet away, playing on the radio, rather than listening to his training and doing his job. Then you heard from Mazzi, the Coral Springs cop. He was the bald guy. He ran in like G.I. Joe. And the defense said he wasn't heroic because he had all the answers. I don't even know what the hell that means. What I know is, from that video, that man ran into that building just like a firefighter who runs into a fire, not caring about his own safety, to try to help those kids. Polar opposite of the guy sitting over there. Polar opposite. You heard from Marian Kabachenko. In this country, 2 weeks, gets shot, runs out of the building. Once again, a victim in this case. You heard on defense's closing about Ernie Rospierski, the teacher who unfortunately locked his keys. Remember what Marian called him on the stand? When Rospierski told him to get out, Marian called him a hero. Because under a tough situation, unimaginable situation, frankly, a shooter on the 3rd floor, your classroom locked, your keys inside, you're waiting for him to reload to get the kids out. Some of the kids, unfortunately, did not get out. They didn't, but some of them did. And you heard Marian call him a hero. And to blame him, that's disgusting. You heard from Armand Borjai, who saw the defendant outside gun draw, scanning the area. Scanning the area. Sees the kids from 700 running out and running back, chooses not to go in. Ashley Passeltiner, one of the students coming out of the 700, who, when she heard the loudest noise of her life, ran back in. She testified in defense said about the echo. Well, if you're a police officer and you're trained, and you're a police officer for 32 years, and a shooting is happening, and you can't hear because of an echo, what do? You move. This is where Peterson is. You hear an echo here. You can go this way. You can go further down and up. There's things to do. You don't just stand there. This echo, 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 echo. If you can't hear, you move. If you can't see, you move. I don't need to go to police academy to know that. You heard from Coral Springs Officer Best. And they're making hay, they're making a big deal that Best didn't go into the 1200 building. Well, Best arrived there after the shooting's over. Best is liaisoning with him to gather information. And what does he tell him? Shooter, 1200, second and third story. Would have been something nice to tell Tim Burton, your friend, and I'll get to Tim in a second. Next, you heard from Richard Vanderings, the BSO deputy. You saw him on the body cam. The reason he was called to show that BSO deputies know what to do when they follow their training. He's pushing. You see it in the body cam. He's moving as quickly as he can. And this is when shots have stopped. Remember, there's a huge difference, a very important difference when shooting is going on and when the shooting is done. He's there when shooting is done and he's pushing as quickly as possible. Why? To stop the bleeding. Tim Burton. Tim Burton dropped off the 1200 building by Medina. The same building that Peterson's dropped off by Medina.
Hello, Erica. Nice to have you
finds
here.
out the description of Cruz. Medina had that information when he dropped Peterson off. And they're making a big deal. Oh, did Medina tell him? Use your common sense. Just like Greenleaf said on the stand when he looked in his eyes and he knew he wasn't going in. Greenleaf couldn't, he said it's possible they had that conversation. It's the exact same information Medina gave to Burton just a few minutes later. And also with Burton. When Burton arrives on scene, defense in their closing said he was facing the 1200 building. Now you can recall on your own what the testimony is, but I'll tell you that's wrong. That when Burton got there, his friend told him the parking lot, so he turns around exposing his back to the 1200 building. Thank God the shooter is gone, or else he could have gotten a bullet in his back from his friend for 7 years, who he called Scotty. Once again, priority of life to Mr. Peterson was Mr. Peterson, then everyone else. And you saw Burton, big dude. And Peterson tells him, don't know where the shots are coming from. Why? Why does he tell Tim Burton that? Because Tim Burton would have went in. And if Tim Burton goes in, guess who basically has to go with him? So instead, he says, check the parking lot. But use your common sense. By the time Burton gets there, Miller's already up on Holmberg. Other BSO officers are already up on Holmberg. They can see that whole parking lot from where they are. It's a total fiction. Total fiction. They hear about the +1 in training. They said, no, let's say parking lot. Because he wasn't going in no matter what.
Very different style than his counterpart, but
You heard from
I
Miss
think very
Lapel,
effective too.
who got shot to get her students in that room, to protect the kids. You heard from Brett Schroy from Coral Springs. Defense says, oh, he doesn't give intel to the defendant. The defendant is the first deputy on scene. He is literally.
Oh no, it's much better
the
than
real-time
defense clothing by
intelligence.
far.
Literally.
It's not the same style, but
But he
it's.
chose not to look in the windows.
I
open
think
the
rebuttal
door,
almost by
or anything.
necessity has to be more impromptu, because you have to respond to what the defense said. So you
heard
can
from
try to
police,
practice it out a little bit, but
and
it
Detective
necessarily is
Suarez.
going to be more improv. So I think he's doing perfectly
It's
fine for
actually
rebuttal.
quite important. You heard from the detective.
He's still like way more organized
No fragments
than the defense
came out.
was, who had all the time in the world to
No
prep.
bullets came out.
You know,
the
he had
south side
lunch
of the
break to
second
prep basically,
floor.
and he has to eat presumably.
Defense concocts a story
Well,
about
then
a
maybe
sniper
not.
fall. There were no bullets. There's no round
Skip lunch,
confirmation.
eat a power bar or
It didn't
something.
happen. You heard from Danny Polo in The Mask. Went in to save lives, and the defendant had the audacity to say that if the defendant had the same information, he would have done the same. The defendant was there, supposed to gather real-time intelligence that didn't move for 48
Thank you,
minutes.
Sandra, for the super
Didn't
chat.
even help with the
Appreciated it.
rescue effort. Yet he's going to besmirch heroes like Danny Polo.
Yeah, it's organized.
Moving on.
It's
You heard from Gloria Crespo, crime scene. I can take out the shells.
Doing fine.
70 shots on the third, I'm sorry, let me just start back. 61 shots on the third floor. 61. And if you remember her testimony, 28 of them were from the east side. Why is that important? Because on the east side is where the defendant's near. 28. So even if they want to say, oh, it's 73 yards away.
Yeah, I mean, the
it's only
defense had-
73 yards. Well, you heard testimony.
defense had
that
2
28
weeks
of
to
those
write a
shots
closing.
were on the east side of the building. That's much closer to the defendant. You also heard that she's in charge of the school resource officers
So,
of Deerfield. And she explained
what's
the
their
responsibilities,
excuse?
the mentorship, administrative searches, the differences between regular, standard road patrol cops and school resource officers.
and he had to beg the
Her
judge for the
testimony
right to proffer more.
highlights-
Oh my God.
Highlights that they're
Kill me.
characters. They're different than regular officers.
Yeah, it was tilapia. It was fine.
You heard from
Could have used some
DeRosa.
tartar sauce, or I could have used some tomato and lettuce and something and
Once again, I
cheese
can
and
show
put it
you
on
the
a
video.
piece of bread.
From the camera angle.
It was a little
at
dry
13.
by itself, but it was
Towards the
fine.
end. Because remember, Peterson's there until 3:11. At about, I'll give you a time, you can write it down if you want to or not. But at about 3:01:59, you see DeRosa with a whole bunch of other cops searching the area, clearing the buildings. And what is Peterson doing at this time? Take a guess. Hasn't moved. You heard from the Emmys. Awful testimony. Needed to be put on to show the injuries. You heard from Sandra. And on cross, defense started off with, here we go, folks. This is the head of training. This is the guy that trains all the other cops what to do. And I'm not going to go through all of his testimony. He was on the stand for hours. What's the most important thing to glean from that testimony? That when you hear shots, you go towards the shots. Defense said in their closing, we still don't know what he was supposed to do. Yeah, we do. Yes, we do. We know exactly.
Yes, if you would
Ask
lick
any
that
cop
button,
what to do
that would be
when you hear
great.
shots.
Lick the
You go
like
to the sound
button.
of shots. You
Or
seek
lick
out
the like button or
the
whatever.
shooter. You gather intelligence. Your mere presence will stop it. You can look at the training. It's in that yellow folder. You can look through it all. It's all right there. You heard from Calvin Greenleaf, and I already talked about his testimony, but the most important thing is he's standing right next to the defendant when they're dropped off by Medina. And when those shots were shot into Coach Weiss, and they ran away, he was standing right next to him. And his testimony was 1,200. That's the best vantage point, the best witness for us, because he was standing, he said, within 5 feet of them. And you heard from Cardinale. You heard from Cardinale that his kid was in this building. The BSO officers are telling him to stay back because of Peterson's instructions. And his kid's in the building. And what does a real parent do? Not my kids, but a real parent. He said, fuck you, and he ran into that building. And he ran over there because his actual kid is in that building. And he is going to save his kid. Not my kids. And lastly, you heard from Curcio, Detective Curcio. Now his job was to investigate the shooter, not him. But one of the responsibilities is to talk to the first person on scene. And you hope they tell you the truth. Well, in this case, they didn't. Because 2 to 3 shots, it's not just said one time. The whole transcript. It's 36 pages. Page 9. How many rounds do you think you heard? It wasn't many, 2 to 3. I can see down the sidewalk looking out west. I get a good dimensional of that whole building at that point. Why is that important? For the kids running out with the balloons and for when Cruz runs out the west side. His own words, 2 days after the shooting.
Don't talk to the police, kids. Just your friendly reminder once again to please don't talk to the police. No good cause
Right here,
to talk to the
page 12.
police.
And what happens from there? He's talking about Tim
Talking to the
Burton.
police is a bad idea. Please don't do
No more
that.
gunshots. It's not that he says 2 to 3 one time. He says it 3 times. You're going to get a copy of the information. That's like the charging documents the judge explained. He doesn't say it one time, saying, oh, Curcio didn't ask me in chronological order. He backs up his lie. He says it 3 times. The other part about the kids coming out of the building, page 14.
The perjury count is so fucking thin.
Right here. But we didn't see any kids. When I was there on scene, there were no individual kids running out. Okay, so there was no kids that ran out to say to you guys, hey, there's a guy up there or anything. No. You didn't see any kids until people started being evacuated by the police. Yes. That's a lie. That's perjury. It's that simple. And I could do that for all the defense witnesses, but I'm just going to lump them, save us some time. You heard from a few witnesses who weren't on scene during the shots. And let's be honest, that's the
Everything you say can and will be used against you. Doesn't matter what you say, it will all be used against you, because they will find a way. They will find a way.
Trying to do something even though shots are over. You heard from Oakley. What did Oakley say? He could have asked for a patch at any time. He's the first responder. Defense is trying to blame all this patch stuff. He just had to ask for it. Then you heard from Mines, Angela Mines, head of the regional communication. And what did she say? Throttling doesn't occur until they're at capacity. That means when all of BSO responded, yeah, there were radio issues. You heard from DeVita, defense witness, that when Captain Jordan queued up the first time, guess what? It worked. They weren't at capacity yet. The radios were working. You can hear it on the dispatch yourself. Was it a little staticky? Sure. Children were called to say they didn't know where the shots were coming from. Children. Kids. Who said, I thought a bomb went off. You heard Dylan Redshaw say, he was wondering where the cops were. These kids ran predominantly back to the 700 building, away from the 1200 building, mind you, because this was the most startling, scary moment of their young lives. You heard from teachers.
Uh-oh, Sandra, that's dangerous.
Based on their training,
You let a
their
police
program
officer
training,
into your
all
home?
of that
Oh,
testified
my
their
God.
responsibility to protect the kids. It's not their job to seek out the shooter. It's not their job to
Sandra
seek out the
hopes it's
sounds of
covered by
gunshots.
spousal privilege, and I'll tell
It's
you
their
what.
jobs to protect those kids. That's what they did. And you heard from cops who at the very tail end of the shooting got there. You heard from Kratz, who proactively was trying to save those kids on the bus line after he got information to set up a perimeter from him. Contrary to training, Kratz didn't know what was going on. He wasn't standing 10 feet from the building when the first shots were happening. So he listens, and he ends up helping Kyle as well. You had Miller. Yeah, he's the sergeant, but you heard from him. Rank doesn't matter at that juncture. When you're the first responder, you call out what to do. Miller's locking down the intersection. That's what he was told to do. You heard from Goolsby. Goolsby ultimately makes entry and gets up to the 1300 building. He's doing something proactive. He heard shots, not sure where because he's 100 yards away and he only heard a couple shots, but he tries to do something. You heard from Stombaugh, who when it went out at the radio, Overwatch on Sawgrass, he went to the Sawgrass. And you heard from Perry. Who,
Ice cream does sound
I
good.
hate that I have to say something good about him, but at least he scanned the area to the football field. He wouldn't say they were his kids, and he wouldn't say it was his school, but at least he did something. And let me remind you about all of those officers. They are not the SRO of Douglas. They are not the caregiver for Douglas. He is. You heard from Sandra Rennie that when she saw Peterson run, she thought he was doing something, investigating. But boy, was she wrong. Because it was the exact opposite.
I've got some Neapolitan ice
He was
cream
running
sandwiches
stand
in the
corner
freezer.
For 48 minutes.
I want one. And or a drink. And or ice cream. And or a drink.
Now, I'm going to go back kind of what I was talking about earlier. About what the defense's theory is. About the 1200. Even if it was just firecrackers, even if he just thought firecrackers, his job is to go and figure that out. His job was to go into that building. And once he determined, based on the dispatch, shots fired, that those are gunshots. His
Heavy
job is
cream
just
over
mere
strawberries and
presence.
topped with nuts is not a bad idea.
Now, obviously, we recognize that Scot Peterson did not murder the people in the building. Nicholas Cruz did. This isn't a murder trial. This is a child neglect, culpable negligence, and perjury trial.
Is it?
Why those charges? Because that's what he did. Once again, going back to the elements, it's a checkbox. That's what he did.
Ice cream with
Defense
vanilla
used an
fudge
example
toppings. Oh, that
of
sounds good.
silent. And when you're on the
Get
road,
myself a sundae delivered to my
You hear a
house.
siren.
Oh,
you don't know where it's coming from. But let's take that a little bit further. When you're on the road and you hear a siren,
I'm a gaze click.
what do you do?
Yes.
You look, and you keep looking until you find the ambulance or the fire truck. And what do you do if it's behind you? You move. You take action. You do something. You look in the windows. You open up the door.
The legal definition of caretaker will be in the
After
jury
it's all
instructions,
over, you go help with the kids
which will
that
be
were shot.
interesting on a number of levels, to be
If you
honest.
truly think, oh, it could be 1300 building, then you go investigate the 1300 building. If you hear shots fired from Kratz and you believe that, although you know better because you're standing 75 feet from where the shots are actually happening, then you go to the football field. You don't just stand in that corner. That's not what you do. He knew enough, Peterson knew enough to do something, but he chose to do nothing.
Okay, a little repetitive. Not bad for rebuttal. It's fine. Land the plane. Time to land the plane.
There was another little theatrical thing I was going to do for you guys and play it, downloaded now yesterday, to show 4 minutes and 15 seconds. And I was going to stand up here and not say a word for 4 minutes and 15 seconds. But based on your faces right now, I'm not going to do that to you. But I do want you to realize, when you take that evidence back, that in that 4 minutes and 15 seconds, all of those shots that were heard, all of the shell casings, in those 4 minutes and 15 seconds, where mere seconds matter. Joaquin Oliver was killed. Scott Eagle.
Nice.
Killed.
Finish with the images. Finish with the faces. Very nice touch on the finish.
Middle column,
Approved. Approved. You just picked up a point, sir.
Peter Wang
You picked up a point
was killed.
in this closing.
Carol Lockrow.
The same way the fence lost a point in their end. You picked up a point. Nice close.
Defenses all
Nice
4 minutes,
finish.
15 seconds. What was he to do? It took SWAT 30 minutes, 10 minutes. Remember, SWAT didn't hear shots. SWAT didn't hear shots. He did. He knew where it was going on, and he chose to do nothing. The priority of life was not Kara. It was Scott.
You're stepping on your own ending, though. You should have stopped with that. Don't make me take a point back. Stop. Stop talking. Stop.
Prosecuting a police officer is not a fun thing. Police officers take an oath, just like you guys did back a month ago, when you said to raise your right hand, said you're going to follow the law. Police officers are given a badge, they're given a gun, they're given power. can go into your houses, they can stop you in a car, they can arrest you for committing a crime. With that power comes responsibility.
Really, with great power comes great responsibility. You're ending this with a super bad quote.
With that power comes what you heard from basically every other cop that took the stand. That said, I didn't want to go there. I don't want to be at a shooting, but that's my job. We're paid to do it. And on February 14th, 2018,
All right, sounds like he's
That's what
gonna.
those
It sounds like he's gonna land it.
except for one, the guy sitting back there. He had the badge, he had the gun, he had the responsibilities. He had those kids to take care of as a caregiver, to watch out for their welfare, to make sure they were okay. I mean, you even heard that day he was meeting with someone's father about a fake ID. That's not what regular cops do, they arrest you. He was more than just a cop to those kids. He was their protector, the only one on campus. And when a madman came on campus and did the unthinkable,
Kind of stepped on your conclusion there a little
he
bit, my
chose
friend.
his life
I'll have to take off a half
over
point at least.
everybody else's. And like I said, this isn't fun. But just like those cops have a job to do, we have a job to do. No one is above the law. Not even a police officer. Not even the SRO of the year. Not even the deputy of the year. That when you break the law, you will be held responsible because no one is above the law. Ladies and gentlemen, when you look at those jury instructions and you see those elements, you all know right now, I want you to go in there and read the instructions, but you all know right now, this case is a slam dunk. He neglected those children. He was responsible for them. And the worst thing imaginable to a parent, even Scott Beagle's parents, even though he was an adult, the worst thing imaginable happened. And he stood on the sidelines. And because of that, we're here. And because of that, ladies and gentlemen, he's guilty of every single one of these crimes we charged. Thank you.
Okay. I'm gonna say 7.5.
Okay, Mr. Newland.
Say 7.5. He stepped on his conclusion a little there.
Restroom break, and then I'm going to read the jury instructions to you. Same admonition as always. Please don't discuss the facts of the case, the evidence, the witnesses, or the testimony amongst yourselves or anyone else. When we reach the end of the trial, we're almost there. If you'll leave those notepads in your chairs and step back one moment, I will be right back with you. Thank you.
Yeah. It wasn't perfect. I'll give some notes here. Let me find the thing but yeah. So 7.5 out of 10, I think, is a fair assessment. Of course, in scoring this, we have to consider his role as the rebuttal close, right? So he has to respond to what the defense did. And so he is presumably writing huge chunks of it, in the interim or during it. I mean, he might have prepped a little bit, but he wants to fold in stuff the defense talked about and respond to things the defense talked about. So, depending on the time flow, you might be up instantaneously after the defense stops. And so he had the benefit of lunch. So he had a little bit of time, but not as much, obviously, as the person who started not as much as the prosecution lawyer who started the close, who was basically perfect because they had a lot more time. So we have to score this considering the time factor and his role. So given the time factor and the role, I think he did a good job. He hit the major points he needed to hit. He responded to major points. It was a little bit more floaty at times, a little bit more emotionally appealing at times. It wasn't overly drawn out, though. It wasn't shouty. It was organized. It wasn't as sharp, obviously, as the lead prosecutor or the woman prosecutor. I'm not sure actually who's lead between them. But whoever, it wasn't as sharp, but you wouldn't expect it to be. But it hit all the major points. It went on too long. It would have been better 10 minutes shorter, And it would have been better had he ended with the photographs instead of like stepping on his own conclusion. So 7.5 out of 10. Not bad. Admirable job. Good work. You know, try to maybe have more like maybe like a universal outline, like a one size fits all outline or something, and try to plug in some points. But fine. Don't tell me you bought this shit. Well, I'm giving you my assessment as I just spoke just now. So I'm telling you what I think. I also think that they're going to find him guilty. Given the state of the laws they're going to be informed on, I think they're going to find him guilty. I also think given the state of the laws the judge informs me, I'd probably vote to find him guilty. I don't think they should, because I think the judge misunderstands the law. But, as a juror, I'm sworn to apply the law as I'm about to be instructed, and I think that they have made their case. I think they've made their case. So I'm probably a guilty vote going into this, I'm probably a guilty vote and then overturning myself on appeal because I think it's the wrong legal standard. But yeah, I think the prosecution did a far better job of selling it than the defense did by far and away. The prosecution was the better team, and they had a team. The defense lawyer could have really used someone else to do his openings and closings. Do I know if Kim Potter was released yet? She should have been. I think her time recently ran out. She should have been released, I believe. Yeah. Yeah. On appeal, you've got lots of options. Expose the jury. That's not great. No reasonable jury could convict on the perjury count, and that they're not a caregiver as a matter of law. So on appeal, I think there's some really good options on appeal. He's still going to spend the next 2 years in prison while they're fighting it out, though, probably. House arrest? Oh, you mean for Potter? Yeah, maybe. So, yeah. She's your friend? Well, tell her that we wish her well. And also we wish she had appealed because we think she could have won, but oh well. We think that the judge did her dirty in her case, and she should have appealed. But that's just me. Tell her we said hi. So we're going to hear the charging instructions from the jury. Then we're going to hear juror number 3 get kicked out, possibly excoriated. So we'll see juror number 3 get kicked out, possibly slapped on their ass on their way out the door, depending on how the judge wants to play this. And then we get to hear from the defense again, to no juror, but the defense wanted to proffer the closing they wish they could have given. So we get to hear the defense give the rest of his closing arguments to nobody. I know how excited you are. So you thought we were done. We are not done. We get to hear more from the defense closing argument. Isn't it exciting, everyone? I know how excited you are. More defense closing arguments coming your way. What'd you miss with juror number 3? Well, we're a little bit unsure about exactly what their role is, but they either were the victim's right advocate or a victim that testified in the underlying trial for the criminal prosecution of Nicholas Cruz. So they were involved in some way as a victim themselves or the victim's right advocate for the underlying criminal trial, the Parkland trial. So they have some thoughts when it comes to things, and apparently were observed, like earlier today, hugging the victim's right advocate in this case. And, being cordial with them. So we think juror number 3 might have some bias, and we're kicking their ass out for cause. Yeah, that's what's happening. So yeah, you missed that. Yeah, juror number 3 was seen hugging the victim's right advocate in this case and talking to them, and victim's right advocate reported it to the prosecution. Or immediately reported it to the judge and be like, yeah, as it turns out, what a weird coincidence. As it turns out, juror number 3 either was a victim who testified in the sentencing hearing or was the victim's right advocate for the victims in that hearing. What an amazing coincidence. We think that they're not suitable to be suited, and they were seen hugging the victim's right advocate in this case. So we'd like to excuse them for cause. Yeah. So going great. Yeah. So house is not caught in four deer? That's an outstanding question, which leads me to the question I raised. How is juror number 3 going to leave the courtroom? Will juror number 3 simply be dismissed with the thanks of the court? Or will we have a little bit of an exchange with juror number 3? Will the judge want to share some thoughts with juror number 3? Will they leave through the main door or will they leave through the back door? That's a good question. We're not sure what's happening with juror number 3. Neither are they. Bad news for juror number 3, though. Yeah, juror number 3 is gone. Yeah. Can the judge or jury change the amount of time for sentencing? Sure. The judge can. It's up to 95 years. I have no idea what sentence this guy will actually get. But I have a feeling, like, he's 55 now, right? I have a feeling that anything he gets is going to be a lot. So, yeah, I don't know what he'll actually get in this, though. Yeah. So we may have some further thoughts, maybe have some further discussion with juror number 3. So the order of events are: jury gets the charge, juror number 3 gets the axe, and then defense gives the rest of its closing. Fun and exciting for all of us. What type of prison? Well, possibly contempt. For juror number 3, find you in contempt and put you in the prison, in the courthouse for some period. Send you to jail for contempt. I don't know. We'll see. Does the judge sentence this guy? Yeah, in Florida, I'm pretty sure. Yeah. What type of prison would he be sent to? I don't know. That's usually up to the Bureau of Prisons for the respective state in terms of where he gets sentenced and what kind of confinement they do. So we'll see if juror number 3 is going to have a fun and exciting time. Hey, 347 of you are currently watching. That's really good. Thank you for 347 of you currently being watching. If you'd like to hit the subscribe button, make sure you're still subscribed, because YouTube seems to have a nasty tendency lately of unsubscribing people.
Room. If so, I'm going to have the court deputies assist them in retrieving all their personal items and bringing them back into this courtroom. I'm then going to have the 6 members of the jury retire to begin their deliberations. After that, I'm going to instruct the alternates that all the communication rules remain. I'm going to send them home with the instruction that I will call them and let them know when their service is complete. And should I need to summon one back here for some reason during the deliberations and order that jury to begin their deliberations anew, they will be available to me to do so. And then I'll probably let them go, I would say, at least till 6 o'clock tonight. And they do not reach a verdict by 6 o'clock, send them home. Ask them to be back here at 9 o'clock tomorrow morning. And as soon as I have the jury back, they can resume their deliberations. State, any objection to proceeding in that manner or anything else you need me to address?
No.
Defense, any objection to proceeding in that manner or anything else you need me to address?
No, Your Honor.
Okay, please bring the jury back.
All right, so we're going to have the jury come in, charge all the jury. We'll excuse the jury to deliberate. Juror number 3, not so fast for you. You get to stay behind, probably. You've been replaced. Yeah. Juror number 3 did a bad. Juror number 3 did a bad. Juror number 3 was heavily involved in the prosecution of Nicholas Cruz and testified or assisted other people in testifying at the sentencing hearing, and also hugged the victim's rights counselor in this case. I may be a little bit biased. Yeah. Now, Florida only requires 6 except in capital cases. Why? I don't know, but they do. Yeah, just maybe a little bit problematic. There could be, there are some indicia. There are some indicia that juror number 3 may not be able to be a fully fair and impartial juror in this case. Yeah. Oh, they've already decided to dismiss juror number 3. Juror number 3 just doesn't know it yet. Yeah, they've already decided to dismiss juror number 3. Juror 3 just doesn't know it yet.
Jurors entering.
If it were up to me, I'd decide who deliberates after the trial's over. I wouldn't decide on the ordinance in advance.
Ladies and gentlemen, welcome back. Come on in. Ladies and gentlemen, welcome back. Come on in. Once you're back at the same seat, you may be seated. All parties may be seated. Ladies and gentlemen, those of you that are using the notepads, should you choose, I'll give you a moment to get the notepads out. I will let you know that you should each have an exact copy of the instructions that I'm about to read to you. You will be taking those with you when you begin your deliberations. Besides all the evidence, you will have a copy of the jury instructions, you will have a copy of the charging document, and you will have the 11 verdict forms that I'm going to go over with you momentarily. Okay, so if you want to take notes during my instruction, you may do so. Obviously, if you do not want to, you do not have to. You all have an exact copy of what I'm about to read to you. Members of the jury, I thank you for your attention during this trial. Please pay attention to the instructions I'm about to give you. Scot Peterson, the defendant in this case, has been accused of the crimes of neglect of a child, great bodily harm, permanent disability, or permanent disfigurement. Neglect of a child, great bodily harm, permanent disability, or permanent disfigurement. Neglect of a child, great bodily harm, permanent disability, or permanent disfigurement. Neglect of a child, great bodily harm, permanent disability, or permanent disfigurement. Neglect of a child, great bodily harm, permanent disability, or permanent disfigurement. Neglect of a child, great bodily harm, permanent disability, or permanent disfigurement. Neglect of a child without great bodily harm, permanent disability, or permanent disfigurement. Culpable negligence, culpable negligence, culpable negligence, and perjury not in an official proceeding. To prove the crime of neglect of a child causing great bodily harm, permanent disability, or permanent disfigurement, the state must prove the following 4 elements beyond a reasonable doubt. 1. Scot Peterson willfully or by culpable negligence failed or omitted to provide Anthony Borges with the care, supervision, and services necessary to maintain Anthony Borges' physical or mental health. Or Scot Peterson failed to make reasonable effort to protect Anthony Borges from abuse, neglect, or exploitation by another person. 2. In doing so, Scot Peterson caused great bodily harm, permanent disability, or permanent disfigurement to Anthony Borges. 3. Scot Peterson was a caregiver for Anthony Borges. 4. Anthony Borges was under the age of 18 years. Neglect of a child may be based on repeated conduct or on a single incident or omission that resulted in, or reasonably could have been expected to result in, serious physical or mental injury or a substantial risk of death to a child. Caregiver means a parent, adult household member, or other person responsible for a child's welfare. I will now define what is meant by the term culpable negligence. Each of us has a duty to act reasonably towards others. If there's a violation of that duty without any conscious intention to harm, that violation is negligence. But culpable negligence is more than a failure to use ordinary care for others. For negligence to be called culpable negligence, it must be gross and flagrant. The negligence must be committed with an utter disregard for the safety of others.
In other words,
Culpable
recklessness.
negligence is consciously doing an act or following a course of conduct that the defendant must have known or reasonably should have known was likely to cause death or great bodily harm.
In other words, what we call
Great
recklessness.
bodily harm means great as distinguished from slight, trivial, minor, or moderate harm, and as such does not include mere bruises. To prove the crime of neglect of a child causing great bodily harm, permanent disability, or permanent disfigurement, the state must prove the following four elements beyond a reasonable doubt. 1. Scot Peterson willfully or by culpable negligence failed or omitted to provide Kara Logren with the care, supervision, and services necessary to maintain Kara Logren's physical or mental health. Or Scot Peterson failed to make reasonable effort to protect Kara Logren from abuse, neglect, or exploitation by another person. 2. In doing so, Scot Peterson caused great bodily harm, permanent disability, or permanent disfigurement to Kara Logren. 3. Scot Peterson was a caregiver for Kara Logren. 4. Kara Logren was under the age of 18 years. Neglect of a child may be based on repeated conduct or on a single incident or omission that resulted in, or reasonably could have been expected to result in, serious physical or mental injury or a substantial risk of death to a child. Caregiver means a parent, adult household member, or other person responsible for a child's welfare. I will now define what is meant by the term culpable negligence. Each of us has a duty to act reasonably.
Oh my
towards
God, we're going to
others.
be here for a
If
hot
there is
minute,
vi-
guys.
if
I
there
hope
is
you
a
like hearing this a
violation of
couple
that
times.
duty without any conscious intention to harm, that violation is negligence. But culpable negligence is more than a failure to use ordinary care for others. For negligence to be called culpable negligence, it must be gross and flagrant. The negligence must be committed with an utter disregard for the safety of others. Culpable negligence is consciously doing an act or following a course of conduct that the defendant must have known or reasonably should have known was likely to cause death or great bodily harm. Great bodily harm means great as distinguished from slight, trivial, minor, or moderate harm, and as such does not include mere bruises.
14
To prove the crime of
kids,
neglect of
3
a
adults,
child
I
causing
think.
great
No,
bodily
wait.
harm, permanent disability, or permanent
I don't know.
disfigurement, the state must prove the following four elements.
We're going to be here
beyond
for a minute, though,
reasonable
guys.
doubt. 1.
There's 11
Scot
counts,
Peterson
so 10 of
willfully
these,
or
I
by
think.
culpable negligence failed or omitted to provide Joaquin Oliver with the care, supervision, and services necessary to maintain Joaquin Oliver's physical or mental health. Or Scot Peterson failed to make reasonable effort to protect Joaquin Oliver from abuse, neglect, or exploitation by another person. In doing so, Scot Peterson caused great bodily harm, permanent disability, or permanent disfigurement to Joaquin Oliver. 3. Scot Peterson was a caregiver for Joaquin Oliver. 4. Joaquin Oliver was under the age of 18 years. Neglect of a child may be based on repeated conduct or on a single incident or omission that resulted in, or reasonably could have been expected to result in, serious physical or mental injury or a substantial risk of death to a child. Caregiver means a parent, adult household member, or other person responsible for a child's welfare. I will now define what is meant by the term culpable negligence. Each of us has a duty to act reasonably towards others. If there is a violation of that duty without any conscious intention to harm, that violation is negligence. But culpable negligence is more than a failure to use ordinary care for others. For negligence to be called culpable negligence, it must be gross and flagrant. The negligence must be committed with an utter disregard for the safety of others. Culpable negligence is consciously doing an act or following a course of conduct that the defendant must have known or reasonably should have known was likely to cause death or great bodily harm. Great bodily harm means great as distinguished from slight, trivial, minor, or moderate harm, and as such does not include mere bruises. To prove the crime of neglect of a child causing death, causing great bodily harm, permanent disability, or permanent disfigurement, the state must prove the following four elements beyond a reasonable doubt. 1. Scot Peterson willfully or by culpable negligence failed or omitted to provide Kyle Lehman with the care, supervision, and services necessary to maintain Kyle Lehman's physical or mental health. Or Scot Peterson failed to make reasonable effort to protect Kyle Lehman from abuse, neglect, or exploitation by another person. 2. In doing so, Scot Peterson caused great bodily harm, permanent disability, or permanent disfigurement to Kyle Lehman. 3. Scot Peterson was a caregiver for Kyle Lehman. 4. Kyle Lehman was under the age of 18 years. Neglect of a child may be based on repeated conduct or on a single incident or omission that resulted in, or reasonably could have been expected to result in, serious physical or mental injury or substantial risk of death to a child. Caregiver means a parent, adult household member, or other person responsible for a child's welfare. I will now define what is meant by the term culpable negligence. Each of us has a duty to act reasonably towards others. If there is a violation of that duty without any conscious intention to harm, that violation is negligence. But culpable negligence is more than a failure to use ordinary care for others. For negligence to be called culpable negligence, it must be gross and flagrant. The negligence must be committed with an utter disregard for the safety of others. Culpable negligence is consciously doing an act or following a course of conduct that the defendant must have known, or reasonably should have known, was likely to cause death or great bodily harm. Great bodily harm means great as distinguished from slight, trivial, minor, or moderate harm, and as such does not include mere bruises. To prove the crime of neglect of a child causing great bodily harm, permanent disability, or permanent disfigurement, the state must prove the following 4 elements beyond a reasonable doubt. 1. Scot Peterson willfully or by culpable negligence failed or omitted to provide Jamie Guttenberg with the care, supervision, and services necessary to maintain Jamie Guttenberg's physical or mental health, or Scot Peterson failed to make reasonable effort to protect Jamie Guttenberg from abuse, neglect, or exploitation by another person. In doing so, Scot Peterson caused great bodily harm, permanent disability, or permanent disfigurement to Jamie Guttenberg. 3. Scot Peterson was a caregiver for Jamie Guttenberg. 4. Jamie Guttenberg was under the age of 18 years. Neglect of a child may be based on repeated conduct or on a single incident or omission that resulted in, or reasonably could have been expected to result in, serious physical or mental injury or a substantial risk of death to a child. Caregiver means a parent, adult household member, or other person responsible for a child's welfare. I will now define what is meant by the term culpable negligence. Each of us has a duty to act reasonably towards others. If there is a violation of that duty without any conscious intention to harm, that violation is negligence. But culpable negligence is more than a failure to use ordinary care for others. For negligence to be called culpable negligence, it must be gross and flagrant. The negligence must be committed with an utter disregard for the safety of others. Culpable negligence is consciously doing an act or following a course of conduct.
All right, I've earned ice cream now.
Must have known,
I'm getting
or
ice cream.
reasonably should have known, was likely to cause death or great bodily harm. Great bodily harm means great as distinguished from slight, trivial, minor, or moderate harm, and as such does not include mere bruises. To prove the crime of neglect of a child causing great bodily harm, permanent disability, or permanent disfigurement, the state must prove the following 4 elements beyond a reasonable doubt. 1. Scot Peterson willfully or by culpable negligence failed or omitted to provide Peter Wang with the care, supervision, and services necessary to maintain Peter Wang's physical or mental health. Or Scot Peterson failed to make reasonable effort to protect Peter Wang from abuse, neglect, or exploitation by another person. 2. In doing so, Scot Peterson caused great bodily harm, permanent disability, or permanent disfigurement to Peter Wang. 3. Scot Peterson was a caregiver for Peter Wang. 4. Peter Wang was under the age of 18 years. Neglect of a child may be based on repeated conduct or on a single incident or omission that resulted in, or reasonably could have been expected to result in, serious physical or mental injury or a substantial risk of death to a child. Caregiver means a parent, adult household member, or other person responsible for a child's welfare. I will now define what is meant by the term culpable negligence. Each of us has a duty to act reasonably towards others. If there is a violation of that duty without any conscious intention to harm, that violation is negligence. But culpable negligence is more than a failure to use ordinary care for others. For negligence to be called culpable negligence, It must be gross and flagrant. The negligence must be
Vanilla.
committed with an utter disregard for the safety of others. Culpable negligence is consciously doing an act or following a course of conduct that the defendant must have known or reasonably should have known was likely to cause death or great bodily harm. Great bodily harm means great as distinguished from slight, trivial, minor, or moderate harm, and as such does not include mere bruises. To prove the crime of neglect of a child, the state must prove the following three elements beyond a reasonable doubt. 1. Scot Peterson willfully or by culpable negligence failed or omitted to provide Marian Kabachenko with the care, supervision, and services necessary to maintain Marian Kabachenko's physical or mental health. Or, Scot Peterson failed to make reasonable effort to protect Marian Kabachenko from abuse, neglect, or exploitation by another person. 2. Scot Peterson was a caregiver for Marian Kabachenko. 3. Marian Kabachenko was under the age of 18 years. Neglect of a child may be based on repeated conduct or on a single incident or omission that resulted in, or reasonably could have been expected to result in, serious physical or mental injury or a substantial risk of death to a child. Caregiver means a parent, adult household member, or other person responsible for a child's welfare. I will now define what is meant by the term culpable negligence.
That
Each
was
of
the
us
all
has a
vanilla
duty
one.
to act reasonably towards others. If there's a
That was the all
violation
vanilla
of that
one.
duty without any
I'll get number
conscious
2.
intention to harm, that violation is negligence. But culpable negligence is more than a failure to use ordinary care for others. For negligence to be called culpable negligence, it must be gross and flagrant. The negligence must be committed with an utter disregard for the safety of others. Culpable negligence is consciously doing an act or following a course of conduct that the defendant must have known or reasonably should have known was likely to cause death or
Free
great
flavor.
bodily harm.
Chocolate, vanilla, and
To
strawberry.
prove the crime of culpable negligence, the state must prove the following two elements beyond a reasonable doubt. 1. Scot Peterson exposed Scott Beagle to personal injury. 2. He did so through culpable negligence. Actual injury is not required. I will now define culpable negligence for you. Each of us has a duty to act reasonably towards others. If there's a violation of that duty without any conscious intention to harm, that violation is negligence. But culpable negligence is more than a failure to use ordinary care for others. In order for negligence to be culpable, it must be gross and flagrant. Culpable negligence is a course of conduct showing reckless disregard for human life or for the safety of persons exposed to its dangerous effects, or such an entire want of care as to raise a presumption of a conscious indifference to consequences, or which shows wantonness or recklessness, or a grossly careless disregard for the safety and welfare of the public, or shows such an indifference to the rights of others as is equivalent to an intentional violation of such rights. To prove the crime of culpable negligence, the state must prove the following two elements beyond a reasonable doubt. 1. Scot Peterson exposed Stacy Lapel to personal injury. 2. He did so through culpable negligence. Actual injury is not required.
Ah, that was nice.
I will now define culpable negligence for you. Each of us has a duty to act reasonably towards others. If there's a violation of that duty without any conscious intention to harm, that violation is negligence. But culpable negligence is more than a failure to use ordinary care for others. In order for negligence to be culpable, it must be gross and flagrant. Culpable negligence is a course of conduct showing reckless disregard for human life or for the safety of persons exposed to its dangerous effects, or such an entire want of care as to raise a presumption of a conscious indifference to consequences, or which shows wantonness or recklessness, or a grossly careless disregard for the safety and welfare of the public, or shows such an indifference to the rights of others as is equivalent to an intentional violation of such rights. To prove the crime of culpable negligence, the state must prove the following two elements beyond a reasonable doubt. 1. Scot Peterson exposed Meadow Pollock to personal injury. 2. He did so through culpable negligence. Actual injury is not required. I will now define culpable negligence for you. Each of us has a duty to act reasonably towards others. If there's a violation of that duty without any conscious intention to harm, that violation is negligence. But culpable negligence is more than a failure to use ordinary care for others. In order for negligence to be culpable, it must be gross and flagrant. Culpable negligence is a course of conduct showing reckless disregard for human life or for the safety of persons exposed to its dangerous effects, or such an entire want of care as to raise a presumption of a conscious indifference to consequences, or which shows wantonness or recklessness, or a grossly careless disregard for the safety and welfare of the public, or shows such an indifference to the rights of others as is equivalent to an intentional
How many different ways can you say
violation of such
reckless?
rights.
Damn. Like, how many different ways
To
can you
prove
say
the crime of
reckless?
perjury
Apparently 8
not in
different
an
ways, I
official
guess.
proceeding,
Damn.
the state must prove the following 5 elements beyond a reasonable doubt. 1, Scott Peterson took an oath or otherwise affirmed that he was obligated by conscience or by law
No,
to
and
speak
caramel?
the
That
truth
sounds good
during a
right now.
sworn statement. 2, the oath or affirmation was made to Broward Sheriff's Detectives John Curcio
What
and
the
Jeffrey
fuck?
Curtis.
Sure.
3,
Let me find out
Scott
where, how to
Peterson,
do
while
that.
under an oath, made the statement. Question. Okay, all right, once you
Yeah.
get closer
Long crime
and you hear
says
those
27%
guys, how many
guilty,
rounds do you think you
65%
heard?
not
Answer.
guilty, 50%
It
hung.
wasn't many. 2, 3.
I think long crime has this one wrong, guys.
Okay. Answer. So I'm right there. I'm on the radio. I can hear the units coming. And the next thing while I'm keeping an eye on the door in the building, no shots, nothing anymore. It's quiet. Question. All right, what happens from there? Answer. And Officer Tim Burton, runs up by the tree, and I'm just
I think
telling
it's
you,
gonna
you
be
know what I
guilty,
heard.
just in case
I
you
heard a
care.
couple of shots. Haven't heard anything since. And he's just taking cover by, behind the tree. I'm taking cover here. And units are now starting, no more gunshots, and units are starting to come in. Question. Okay. Now, did you ever see, while everybody is starting to arrive, did you ever see any of the students leave Building 12 at all? Answer. Yes. Question. Which were they all the doors, or answer? No. They were evacuating, and they were telling them to. They were
And
taking
then we lowered
out, and
the
they
court
were-
audio. It's nice for the
kids were
court audio
going
to be
out
too
toward the
loud for a
parking lot.
change.
Question. Okay, but that's when the officers answer. When the officers came. Question. Inaudible. Answer. But we didn't see any kids. No. When I was on the scene, there were no individual kids running out. None. Question. Okay, so there was no kids that ran out to say to
What
you
happens if you
guys,
hung?
hey,
You do it over
there's
again,
a guy
baby.
up there or anything of that? Answer. No. Question. You didn't see any kids until people started being evacuated by the police? Answer. Yes. 4, the statement was false. 5, Scott Peterson did not believe the statement was true when he made it. Knowledge of the materiality of the statement is not an element of this crime, and the defendant's mistaken belief that his statement was not material is not a defense to the charge. In considering the evidence, you should consider the possibility that although the evidence may not convince you that the defendant committed the main crimes of which he is accused, there may be evidence that he committed other acts that would constitute a lesser included crime or crimes. Therefore, if you decide that the main accusations have not been proved beyond a reasonable doubt, you will next need to decide if the defendant is guilty of any lesser included crimes. The lesser crimes indicated in the definition of neglect of a child, great bodily harm, permanent disability, or permanent disfigurement are neglect of a child without great bodily harm, permanent disability, or permanent disfigurement, and culpable negligence. The lesser crime indicated in the definition of neglect of a child without great bodily harm, permanent disability, or permanent disfigurement is culpable negligence.
Okay. Well, I think that greatly increases the probability of guilty because the jury, the probability for a compromise verdict
Scott
is
Peterson
now much
willfully or
higher
by
with all those
culpable
lesser
negligence
included.
failed or omitted to provide Anthony Borges with the care, supervision, and services necessary to maintain Anthony Borges' physical or mental health, or Scott Peterson failed to make reasonable effort to protect Anthony Borges from abuse, neglect, or exploitation by another person. 2, Scott Peterson was a caregiver for Anthony Borges. 3, Anthony Borges was under the age of 18 years. Neglect of a child may be based on repeated conduct or on a single incident or omission that resulted in or reasonably could have been expected
We have a
to
goddamn
result in
ice cream museum
serious
in
physical or
Austin.
mental injury or
You pay one
substantial
price
risk
and you
of
can use
death
as much
to a
ice cream as you
child.
want.
Caregiver means a parent, adult household
I've
member,
never been
or other
there,
person
but we have a goddamn
responsible
ice
for
cream
a
museum.
child's welfare. I will now define what is meant by the term culpable negligence. Each of us has a duty to act reasonably towards others. If there's
I
a
take you guys
violation
on a
of that
field trip
duty
with
without
me
any conscious intention to
sometime?
harm, that
On
violation
some
is
visits to the
negligence.
ice cream
But
museum?
culpable negligence is more than a failure to use ordinary care for others. For negligence to be called culpable negligence, it must be gross and flagrant. The negligence must be committed with an utter disregard for the safety of others. Culpable negligence is consciously doing an act or following a course of conduct that the defendant must have known or reasonably should have known was likely to cause death or great bodily harm. To prove the crime of neglect of a child, the state must prove the following three elements beyond a reasonable doubt. 1. Scot Peterson willfully or by culpable negligence failed or omitted to provide Kara Logren
Blue Bell's
with
fairly
the care,
nearby?
supervision,
That'd be cool.
and services necessary to
tour
maintain
Blue
Kara
Bell, that'd be
Logren's
cool.
physical or mental health. Or Scot Peterson failed to make reasonable effort to protect Kara Logren from abuse, neglect, or exploitation by another person. 2. Scot Peterson was a caregiver for Kara Logren. 3. Kara Logren was under the age of 18 years. Neglect of a child may be based on repeated conduct or on a single incident or omission that resulted in, or reasonably could have been expected to result in, serious physical or mental injury or a substantial risk of death to a child. Caregiver means a parent, adult household member, or other person responsible for a child's welfare. I will now define what is meant by the term culpable negligence. Each of us has a duty to act reasonably towards others. If there's a violation of that duty without any conscious intention to harm, that violation is negligence. But culpable negligence is more than a failure to use ordinary care for others. For negligence to be called culpable negligence, it must be gross and flagrant. The negligence must be committed with an utter disregard for the safety of others. Culpable negligence is consciously doing an act or following a course of conduct that the defendant must have
Thank
known
you, Tammy,
or
for the super
reasonably
chat.
should have
Appreciate
known
it.
was likely to cause death or great bodily harm.
Appreciate it. That's very thoughtful of you. Appreciate everyone
To
who
prove the
supports
crime
this
of
channel.
neglect of a child, the state
It
must
makes a
prove
huge
the following
difference.
three elements beyond a reasonable doubt. 1. Scot Peterson willfully or by culpable negligence failed or omitted to provide Joaquin Oliver with the care, supervision, and services necessary to maintain Joaquin Oliver's physical or mental health. Or Scot Peterson failed to make reasonable effort to protect Joaquin Oliver from abuse, neglect, or exploitation by another person. 2. Scot Peterson was a caregiver for Joaquin Oliver. 3. Joaquin Oliver was under the age of 18. Neglect of a child may be based on repeated conduct or on a single incident or omission.
Yeah,
that resulted in
43% of
or
you say
reasonably
guilty,
could have
31
been
not guilty,
expected
and
to result
26 say
in
hung jury.
serious physical or mental injury
Okay, interesting.
or substantial risk of death to a child. Caregiver means a parent, adult household member, or other person responsible for a child's welfare. I will now define what is meant by the term culpable negligence. Each of us has a duty to act reasonably towards others. If there is a violation of that duty without any conscious intention to harm, that violation is negligence. But culpable negligence is more than a failure to use ordinary care for others. For negligence to be called culpable negligence, it must be gross and flagrant. The negligence must be committed with an utter disregard for the safety of others. Culpable negligence is consciously doing an act or following a course of conduct that the defendant must have known or reasonably should have known was likely to cause death or great bodily harm. To prove the crime of neglect of a child, the state must prove the following three elements beyond a reasonable doubt. 1. Scot Peterson willfully or by culpable negligence failed or omitted to provide Kyle Lehman with the care, supervision, and services necessary to maintain Kyle Lehman's physical or mental health. Or Scot Peterson failed to make reasonable effort to protect Kyle Lehman from abuse, neglect, or exploitation by another person. 2. Scot Peterson was a caregiver for Kyle Lehman. 3. Kyle Lehman was under the age of 18 years. Neglect of a child may be based on repeated conduct or on a single incident or omission that resulted in or reasonably could have been expected to result in serious physical or mental injury or a substantial risk of death to a child. Caregiver means a parent, adult household member, or other person responsible for a child's welfare. I will now define what is meant by the term culpable negligence. Each of us has a duty to act reasonably towards others. If there is a violation of that duty without any conscious intention to harm, that violation is negligence. But culpable negligence is more than a failure to use ordinary care for others. For negligence to be called culpable negligence, it must be gross and flagrant. The negligence must be committed with an utter disregard for the safety of others. Culpable negligence is consciously doing an act or following a course of conduct that the defendant must have known or reasonably should have known was likely to cause death or great bodily harm. To prove the crime of neglect of a child, the state must prove the following three elements beyond a reasonable doubt. 1. Scot Peterson willfully or by culpable negligence failed or omitted to provide Jamie Guttenberg with the care, supervision, and services necessary to maintain Jamie Guttenberg's physical or mental health. Or Scot Peterson failed to make reasonable effort to protect Jamie Guttenberg from abuse, neglect, or exploitation by another person. 2. Scot Peterson was a caregiver for Jamie Guttenberg. 3. Jamie Guttenberg was under the age
Thank you,
of
Maureen,
18
for the gift memberships. It means a lot to me.
Neglect of a
Thank you.
child may be based on repeated conduct or in a single incident or omission that resulted in or reasonably could have been
Appreciate
expected
everyone
to
who
result in
becomes a non-civilian and hits that
serious
beautiful,
physical or
beautiful
mental
join
injury
button. Makes
or
a huge difference to the
substantial
channel.
risk of
Thank you.
death to a child. Caregiver means a parent, adult household member, or other person responsible for a child's welfare. I will now define what is meant by the term culpable negligence. Each of us has a duty to act reasonably towards others. If there is a violation of that duty without any conscious intention to harm, that violation is negligence. But culpable negligence is more than a failure to use ordinary care for others. For negligence to be called culpable negligence, it must be gross and flagrant. The negligence must be committed with an utter disregard for the safety of others. Culpable negligence is consciously doing an act or following a course of conduct that the defendant must have known or reasonably should have known was likely to cause death or great bodily harm. To prove the crime of neglect of a child, the state must prove the following three elements beyond a reasonable doubt. 1. Scot Peterson willfully or by culpable negligence failed or omitted to provide Peter Wang with the care, supervision, and services necessary to maintain Peter Wang's physical or mental health. Or Scot Peterson failed to make reasonable effort to protect Peter Wang from abuse, neglect, or exploitation by another person. 2. Scot Peterson was a caregiver for Peter Wang. 3. Peter Wang was under the age of 18 years. Neglect of a child may be based on repeated conduct or on a single incident or omission that
Thank you,
resulted
Bush, for
in
hitting
or
that join
reasonably
button.
could have been
We
expected to
appreciate
result
everyone
in
who hits the join button.
serious
The
physical
jury
or
can
mental
take notes in
injury
this
or a
courtroom.
substantial
Yes.
risk of death to a child. Caregiver means a parent, adult household member, or other person responsible for a child's welfare. I will now define what is meant by the term culpable negligence. Each of us has a duty to act reasonably towards others. If there's a violation of that duty without any conscious intention to harm, that violation is negligence. But culpable negligence is more than a failure to use ordinary care for others. For negligence to be called culpable negligence, it must be gross and flagrant. The negligence must be committed with an utter disregard for the safety of others. Culpable negligence is consciously doing an act or following a course of conduct that the defendant must have known or reasonably should have known was likely to cause death or great bodily harm. To prove the crime of culpable negligence, the state must prove the following two elements beyond a reasonable doubt. 1. Scot Peterson exposed Anthony Borges to personal injury. 2. He did so through culpable negligence. Actual injury is not required. I will now define culpable negligence for you.
Would you
Each
please?
of us has a duty to act reasonably towards others.
What is
If there's a
culpable
violation
negligence?
of that duty without any conscious intention to harm, that violation is negligence. But culpable negligence is more than a failure to use ordinary care for others. In order for negligence to be culpable, it must be gross and flagrant. Culpable negligence is a course of conduct showing reckless disregard for human life or for the safety of persons exposed to its dangerous effects, or such an entire want of care as to raise a presumption of a conscious indifference to the consequences, or which shows wantonness or recklessness, or a grossly careless disregard for the safety and welfare of the public, or shows such an indifference to the rights of others as is equivalent to an intentional violation of such rights. To prove the crime of culpable negligence, the state must prove the following two elements beyond a reasonable doubt. 1. Scot Peterson exposed Kara Logren to personal injury. 2. He did so through culpable negligence. Actual injury is not required. I will now define culpable negligence for you. Each of us has a duty to act reasonably towards others. If there is a violation of that duty without any conscious intention to harm, that violation is negligence. But culpable negligence is more than a failure to use ordinary care for others. In order for negligence to be culpable, it must be gross and flagrant. Culpable negligence is a course of conduct showing reckless disregard for human life or for the safety of the persons exposed to its dangerous effects, or such an entire want of care as to raise a presumption of a conscious indifference to consequences, or which shows wantonness or recklessness, or a grossly careless disregard for the safety and welfare of the public, or shows such an indifference to the rights of others as is equivalent to an intentional violation of such rights. To prove the crime of culpable negligence, the state must prove the following two elements beyond a reasonable doubt. 1, Scot Peterson exposed Joaquin Oliver to personal injury. 2, he did so through culpable negligence. Actual injury is not required. I will now define culpable negligence for you. Each of us has a duty to act reasonably towards others. If there's a violation of that duty without any conscious intention to harm, that violation is negligence. But culpable negligence is more than a failure to use ordinary care for others. In order for negligence to be culpable, it must be gross and flagrant. Culpable negligence is a course of conduct showing reckless disregard for human life or for the safety of persons exposed to its dangerous effects, or such an entire want of care as to raise a presumption of the conscious indifference to consequences, or which shows wantonness or recklessness, or a grossly careless disregard for the safety and welfare of the public, or shows such an indifference to the rights of others as is equivalent to an intentional violation of such rights. To prove the crime of culpable negligence, the state must prove the following two elements beyond a reasonable doubt. 1, Scot Peterson exposed Kyle Lehman to personal injury. 2, he did so through culpable negligence. Actual injury is not required. I will now define culpable negligence for you. Each of us has a duty to act reasonably towards others. If there's a violation of that duty without any conscious intention to harm, that violation is negligence. But culpable negligence is more than a failure to use ordinary care for others. In order for negligence to be culpable, it must be gross and flagrant. Culpable negligence is a course of conduct showing reckless disregard for human life or for the safety of persons exposed to its dangerous effects, or such an entire want of care as to raise a presumption of a conscious indifference to consequences, or which shows wantonness or recklessness, or a grossly careless disregard for the safety and welfare of the public, or shows such an indifference to the rights of others as is equivalent to an intentional violation of such rights. To prove the crime of culpable negligence, the state must prove the following two elements beyond a reasonable doubt. 1, Scot Peterson exposed Jamie Guttenberg to personal injury. 2, he did so through culpable negligence. Actual injury is not required. I will now define culpable negligence for you. Each of us has a duty to act reasonably towards others. If there's a violation of that duty without any conscious intention to harm, that violation is negligence.
Gotcha, bitch.
But culpable negligence is more than a failure to use ordinary care for others. In order for negligence to be culpable, it must be gross and flagrant. Culpable negligence.
Thank you, Antonia, for the PayPal donation. That's very thoughtful of you.
For the safety of persons exposed to its dangerous effects.
Appreciate everyone who supports the channel.
Care is to raise a presumption of a conscious indifference to consequences, or which shows wantonness or recklessness, or a grossly careless disregard for the safety and welfare of the public, or shows such an indifference to the rights of others as is equivalent to an intentional violation of such rights. To prove the crime of culpable negligence, the state must prove the following two elements beyond a reasonable doubt. 1, Scot Peterson exposed Peter Wang to personal injury. 2, he did so through culpable negligence. Actual injury is not required. I will now define culpable negligence.
Could you please define culpable negligence?
Each of us has a duty to act reasonably towards others. If there's a violation of that duty without any conscious intention to harm, that violation is negligence. But culpable negligence is more than a failure to use ordinary care for others. In order for negligence to be culpable, it must be gross and flagrant. Culpable negligence is a course of conduct showing reckless disregard for human life.
Thank you, Lola.
Or for the safety of persons exposed to its dangerous effects, or such an entire want of care as to raise a presumption of the conscious indifference to consequences, or which shows wantonness or recklessness, or a grossly careless disregard for the safety and welfare of the public, or shows such an indifference to the rights of others as is equivalent to an intentional violation of such rights. To prove the crime of culpable negligence, the state must prove the following two elements beyond a reasonable doubt. 1, Scot Peterson exposed Marian Kavachenko to personal injury. 2, he did so through culpable negligence. Actual injury is not required. I will now define culpable negligence for you. Each of us has a duty to act reasonably towards others. If there's a violation of that duty without any conscious intention to harm, that violation is negligence. But culpable negligence is more than a failure to use ordinary care for others. In order for negligence to be culpable, it must be gross and flagrant. Culpable negligence is a course of conduct showing reckless disregard for human life or for the safety of persons exposed to its dangerous effects, or such an entire want of care as to raise a presumption of a conscious indifference to consequences, or which shows wantonness or recklessness, or a grossly careless disregard for the safety and welfare of the public, or shows such an indifference to the rights of others as is equivalent to an intentional violation of such rights. The defendant has entered a plea of not guilty. This means you must presume or believe the defendant is innocent. The presumption stays with the defendant as to each material allegation in the information through each stage of the trial, unless it has been overcome by the evidence to the exclusion of and beyond a reasonable doubt. To overcome the defendant's presumption of innocence, the state has the burden of proving the crime with which the defendant is charged was committed, and the defendant is the person who committed the crime. The defendant is not required to present evidence or prove anything. Whenever the words reasonable doubt are used, you must consider the following. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. On the other hand, if, after carefully considering, comparing, and weighing all the evidence, there is not an abiding conviction of guilt, or if having a conviction, it is one which is not stable, but one which wavers and vacillates, then the charge is not proved beyond every reasonable doubt, and you must find the defendant not guilty because the doubt is reasonable. It is to the evidence introduced in this trial and to it alone that you are to look for that proof. A reasonable doubt as to the guilt of the defendant may arise from the evidence, conflict in the evidence, or the lack of evidence. If you have a reasonable doubt, you should find the defendant not guilty. If you have no reasonable doubt, you should find the defendant guilty.
Is it over? Is it over?
It is up to you to decide what evidence
No.
is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon in considering your verdict. You may find some of the evidence not reliable or less reliable than other evidence. You should consider how the
Can I
witness
become
is
a judge?
acting,
Can
as
I
well
just
as
get a
what they
text-to-speech
said.
thing to
Some things you should
read this
consider
for me? Is
are,
that legal?
Did the witness seem to have an opportunity to
I just
see
get
and know
like
the things
deep
about which
fake
the
my own
witness
voice
testified?
and just press
Did the
play?
witness seem to have an
Is that
accurate
legal?
memory?
We
Was
might
the
find
witness
out.
honest and straightforward
We might
in
find out in
answering the
uncivil
attorney's
courtroom if
questions?
that's legal or not.
Did the witness
If I
have
just
some interest in
have
how
it
the
run through a
case should be
text-to-speech
decided?
generator,
Does
can
the
I like
witness's
not say all
testimony
these
agree with
things?
the
Is that
other
legal? We may
testimony and
find
other
out
evidence in the
together.
case? Did the witness at some other time make a statement that is inconsistent with the testimony he or she gave in court? Whether the state has met its burden of proof does not depend on the number of witnesses it has called or upon the number of exhibits it has offered, but instead upon the nature and quality of the evidence presented. The fact that a witness is employed in law enforcement does not mean that his or her testimony deserves more or less consideration than that of any other witness. Expert witnesses are like other witnesses with one exception. The law permits an expert witness to give his or her opinion. However, an expert's opinion is reliable only when given on a subject about which you believe him or her to be an expert. Like other witnesses, you may believe or disbelieve all or any part of an expert's testimony. It is entirely proper for a lawyer to talk to a witness about what testimony the witness would give if called to the courtroom. The witness should not be discredited by talking to a lawyer about his or her testimony. You may rely upon your own conclusion about the credibility of any witness. A juror may believe or disbelieve all or any part of the evidence or the testimony of any witness. The Constitution requires the state to prove its accusations against the defendant. It is not necessary for the defendant to disprove anything, nor is the defendant required to prove his innocence. It is up to the state to prove the defendant's guilt by evidence. The defendant exercised a fundamental right by choosing not to be a witness in this case. You must not view this as an admission of guilt or be influenced in any way by his decision. No juror should ever be concerned that the defendant did or did not take the witness stand to give testimony in the case. These are some general rules that apply to your discussion. You must follow these rules in order to return a lawful verdict. You must follow the law as it is set out in these instructions. If you fail to follow the law, your verdict will be a miscarriage of justice. There is no reason for failing to follow the law in this
Mass
case.
couple testifies forced
All of us
to
are depending
take his
upon you to
mask
make a
off.
wise and
In
legal
trial, his wife
decision
had a
in this
family
matter.
photo on social
This
media.
case
That's
must
pretty
be
funny.
decided only upon the evidence
You got
that you have heard from the
exposed.
testimony of the witnesses
That's pretty funny.
and have seen in the form of the exhibits and evidence and these instructions. This case must not be decided for or against anyone because
might
you
have
feel
watched that
sorry
just for the
anyone
schadenfreude
or
of
are
it all.
angry at anyone. Remember, the lawyers are not on trial. Your feelings about them should not influence your decision in this case. Your duty is to determine if the defendant has been proven guilty or not in accord with the law. It is the judge's job to determine a proper sentence if the defendant is found guilty. Whatever verdict you render must be unanimous. That is, each juror must agree to the same verdict. Your verdict should not be influenced by feelings of prejudice, bias, or sympathy.
It was on his wife's
Your
Cash App
verdict must be
account, a
based
family
on the
picture.
evidence and on the law
That is
contained
funny
in
as
these
shit.
instructions. Deciding a verdict is exclusively your
Was
job.
that discussed in the
I cannot
courtroom
participate
itself?
in that
Did
decision
they
in
say
any
why?
way.
They bring
Please
out the whole thing
disregard
or motions
anything
and
I may have
shit?
said or done
Is it
that
so I
made
might
you
go
think
watch
I
that?
preferred one verdict over another. You may find the defendant guilty as charged,
I might have to
or
watch
guilty of
that
such
shit.
lesser included crimes as the evidence may justify, or not guilty. If you return a verdict of guilty, it should be for the highest offense on the verdict
that's pretty
form for
good.
each count that has been proven beyond a reasonable doubt. If you find that no offense has been proven beyond a reasonable doubt, then of course your verdict must be not guilty.
So they
The
talked
verdict
about
must
it
be
and they did their
unanimous.
homework.
That is, all of you must agree to the same
I'm gonna have to
verdict.
go watch that shit.
Only one verdict may be returned as to each crime charged.
Told about the picture on the
The
Cash App
verdict
and
must be in
immediately wants to
writing,
step
and
out
for
courtroom
your
and call his
convenience,
wife.
the necessary verdict forms have been prepared
Oh,
for you.
wow.
They are as follows.
That's funny.
Ladies and gentlemen, I know it's hard to see from over there, but you have a one-page verdict form for each of the 11 counts. All of them have the state of Florida plaintiff versus Scot Peterson defendant with this case number, and then they're labeled.
We might have to go watch that. Can you give me a
We, the jury,
timestamp for when that
find
starts
as
this
follows
morning,
as the
or
defendant in this case, check
can you tell me
only
exactly
one.
where to go
Read
look
that
in some
right
link or
here.
something
Check
so I can
only
go
one.
find that? Because
There are
I
four
might want to
choices.
watch that. That sounds like some
The
some
defendant is
good
guilty of
schadenfreude
neglect
for
of
us
child, great
to
bodily harm,
cleanse our
permanent
palate.
disability, or permanent disfigurement as
Sandra!
charged in the information.
Help!
B, the defendant is guilty of neglect of a child without great bodily harm, permanent disability, or permanent disfigurement, a lesser included offense. C, the defendant is guilty of culpable negligence, a lesser included offense. D, the defendant is not guilty. So say we all this blank day of June 2023 at Fort Lauderdale, Broward County, Florida, and there's a place for the foreperson to print their name and sign their name. So once you've come to unanimous verdict as to count one, you will check the appropriate box. The foreperson will date the
All
verdict
right.
form.
Sandra's
print
looking
their
into
name,
it.
and
Sandra
sign
will
their
save
name.
us.
Since the same crime is alleged in counts 1 through 6, the verdict forms for count 1 through 6 are identical. They each have the same 4 choices. You can match up the verdict form for each count with the copy of the information that you will have. The verdict form for count 7 reads as follows. It has 3 choices. We, the jury, find as follows as the defendant in this case. Check only one. A, the defendant is guilty of neglect of a child without great bodily harm, permanent disability, or permanent disfigurement as charged in the information. B, the defendant is guilty of culpable negligence, a lesser included offense. C, the defendant is not guilty. So say we all this blank day of June 2023 at Fort Lauderdale, Broward County, Florida. Again, a place for the foreperson to print their name and sign their name. So once you have come to unanimous decision as to count 7, you will check the appropriate box. The foreperson will date the verdict form and print and sign
Vice's
their name.
stream, time 37.
The verdict forms for count
All right, we'll go
8,
check out Vice's
9,
stream.
and 10 are identical as they all charge the same crime. They all read as follows. This is the verdict form for count 8. We, the jury, find as follows the defendant in this case. Check only one. There's 2 choices. The defendant is guilty of culpable negligence as charged in the information. Or B, the defendant is not guilty. So say we all, this blank day of June 2023 at Fort Lauderdale, Broward County, Florida. And again, a place for the foreperson to print their name and sign their name. So once you've come to unanimous decision as to the verdicts into count 8, 9, and 10, you will fill out, check the appropriate box. The foreperson will date it, sign their name, and print their name. The verdict form for count 11 has 2 choices. It reads as follows. We, the jury, find as follows as the defendant in this case. Check only one. A, the defendant is guilty of perjury not in an official proceeding as charged in the information. B, the defendant is not guilty. So say we all this blank day of June 2023 at Fort Lauderdale, Broward County, Florida. Again, a place for the foreperson to print their
Lesser
name.
includes, I mean, legally this
So
should
once
be
you have
allowed.
reached
I
unanimous
can't think of any
decisions,
reason to
count 11,
legally
you will
preclude
check the
it.
appropriate box. The foreperson will date the verdict form and print and sign the verdict form. A separate crime is charged in each count of the information, and although they have been tried together, each crime and the evidence applicable to it must be considered separately, and a separate verdict returned as to each. A finding of guilty or not guilty as to one crime must not affect your verdict as to the other crimes charged. In just a few moments, you will be taken to the jury room by the court deputy. The first thing you should do is choose a foreperson who will preside over your deliberations. The foreperson should see to it that your discussions are carried on in an organized way and that everyone has a fair chance to be heard. It is also the foreperson's job to sign and date the verdict forms when all of you have agreed on a verdict and to bring the verdict forms back to the courtroom when you return. During deliberations, jurors must communicate about the case only with one another and only when all jurors are present in the jury room. If a juror goes to the restroom, the deliberations should stop until that juror returns. You are not to communicate with anyone outside of the jury about this case. Until you have reached a verdict, you must not talk about this case in person or through the telephone, writing, or electronic communication, such as a blog, Twitter, email, text message, or any other means.
He didn't say you
Contact
can
anyone to
call on
assist
civil
you
law and
during your
talk to us about your jury experience,
These communications
especially
will
you,
apply
juror number
until I
3,
discharge you
since
at
you're
the
going to
end
be
of the
available to
case.
talk real
If you become
soon.
aware of any violation
So
of
juror
these
number 3, if you'd like to
instructions
come
or any
on,
other
I'll send you a
instruction that
link.
I have given in this case, you must tell me by giving a note to the court deputy. Many of you may have cell phones, tablets, laptops, or other electronic devices here in the courtroom. The rules do not allow you to bring your phones or any of those types of electronic devices into the jury room. Kindly
Anyone
leave
know
those
juror number
devices
3?
on
Can
your
we drop
seats,
him a link?
where they will be
Join the
guarded by the
chat.
court deputy while you deliberate. Excuse me. If you need to communicate with me, send a note through the court deputy. If you have voted, do not disclose the actual vote in the note. If you have a question, I will talk with the attorneys before I answer, so it may take some time. You may continue your deliberations while you wait for my answer. I will answer any questions, if I can, in writing or orally here in open court. During the trial, items were received into evidence as exhibits. You may examine whatever exhibits you think will help you.
You think juror number 3? Yeah, juror number 3 may not
These
be
exhibits will
helpful.
be sent into the jury
We'll see on
room
juror
when
number
you
3's
begin to
availability.
deliberate. In closing, let me remind you that it is important that you follow the law spelled out in these instructions in deciding your verdict. There are no other laws that apply to this case. Even if you do not like the laws that must be applied, you must use them. For more than 2 centuries, we have lived by the Constitution and the law. No juror has the right to violate the rules we all share. Quick sidebar with the attorneys, please.
So do you want me to bash jurors number 3's brains in now, or anyone want me to do that, or? Here's the music for juror number 3.
Okay, ladies and gentlemen, everyone is feeling healthy, ready to deliberate. If anyone's having a problem, raise your hand. Okay, I don't see any hands. Okay, ladies and gentlemen, again, we're going to do this by number, by the number that's on the back of your lanyard. Where is juror number 3? Juror number 8, 9, 10. Jurors number 3, 8, 9, and 10, you all are the alternate jurors. Just you 4. Do you have any of your personal items in the jury room right now? Okay. The court deputy is going to escort you back. The other 6 of you, please remain in your seats. And I'm going to have you 4 get those personal items and come right back here, and I will wait for you.
Yeah, I need your personal items. Do you have a toothbrush in your thing? Go get your stuff. Yeah, judge is handling this. Judge is handling this like a pro. He's handling like, get your stuff. Yeah, being on alternate would suck. Go get your eggs. Nice callback. Nice callback. Yeah, I brought in a bunch of eggs for the jury. Eggs? Yeah, I brought in a bunch of eggs for the jury to eat. You want your eggs back? I do want my eggs back. Okay. Help them retrieve their eggs. Yeah, that was one of the weirder moments we've seen in court ever. It's like, what personal items do you have? Eggs. Okay. Yeah. Oh, the Hutch juror number 3 about to get scolded. About to get scolded. About to get whacked. Whacked around. So there's a couple versions of what's about to happen. Juror number 3, you're excused, is the nice version. It gets less nice from there. Yeah, maybe I'll just dismiss her without really bringing a lot of attention to it.
Okay, ladies and gentlemen, welcome back. You can go right back to the seats.
We'll see.
Okay, I've got everyone back. You have all your personal belongings from the jury room. Okay, so the 4 of you, 3, 8, 9, and 10, if you will remain in your seats, I have separate instructions for you. The rest of you, ladies and gentlemen, which is 1, 2, 4, 5, 6, and 7, you may now retire to begin your deliberations. You can take the notepads with you. Momentarily, we will send back to you the verdict forms, a copy of the charging document, as well as all of the evidence. So at this point, you may retire to begin your deliberations.
Take your notebooks.
Well, she may not know something's up. She may not know something's up yet.
Okay, we're outside the presence of the jury. Everyone can be seated. So, ladies and gentlemen, 4 of you, your jury service has not concluded at this point, okay? You are going to be under the same communication rules, all the rules the same as I've instructed you throughout the entire trial for the following reasons, okay? Again, I place no time limit on the deliberations. The jury may take as short or as long a period of time, but, and it has happened in the past, sometimes things come up and we have an emergency with a deliberating juror. If that were to occur, and I had to replace one of the deliberating jurors, I would do that with one of you since you have heard all the evidence in the case. So I still don't want you to talk to anyone about the facts of the case. I don't want you to do any research, nothing on the internet, no newspaper, no television news, no social media. Momentarily, we're going to get you, and BSO is going to escort you out of the building. I will keep your notes in the notepads. We're going to lock them up. I want you to keep the lanyards. Okay, I have your phone numbers. If the jury reaches a verdict, I will call you and let you know that you're discharged at that point, and then at that point you're free to talk to anyone you want about this case, or you're free to talk to no one about this case. That will be up to each of you. But until I call you, please operate under the same rules as I've been instructing you since all the way back on June the 5th. Again, I may need you, one of you, or more than one of you, and again, it has happened in the past. Does anyone have any questions about that at this point? So I'm not going to give you a specific day or time to come back. Resume your normal lives. Keep the lanyard. I will keep your notes. If and when your jury service is concluded, I will call you and let you know. And then, believe it or not, I usually just ask the people to mail the lanyards back. And
We may not be done with juror number 3 yet. We'll see.
back to us. And unless you have any other questions, again, with the same admonition, please don't discuss the facts of the case, evidence, witnesses, or testimony. That would be included amongst yourselves as well as you're walking out. Again, with my great thanks for your time, effort, and energy throughout the entire process. And there's also a certificate and a thank you letter that my
you get a
office will
certificate?
deliver
How
to you,
nice.
But that will be after your jury service is concluded, which isn't just yet, but hopefully will be soon.
It is for juror number
That
3. I
being
wonder if
said,
juror number 3 gets a
hope you all have
certificate.
a good night. I wish you a good return to your lives tomorrow, and then I will be in touch with you when you're going to be discharged. So at this point, have a good night. Talk to you soon.
I guess we're not beating juror number 3 over the head. Oh, how disappointing. Very sad.
Okay, we're outside the presence of the jury. Everyone can be seated. So I'm going to do a quick recess, but then I'm going to need the lawyers to come up, take a look at the verdict forms, the dummy copy of the charging document, all of the state and defense exhibits and evidence. Then I'll go back on the record. I'll let C decide if they have any objection to any or all of those items going back to the jury. Once you tell me that you don't, or I address any issue that comes up in that regard, I'll send everything back to the jury. Like I said before, I think I'll let them go probably to about 6 tonight. So then we would otherwise be in recess till we hear from the jury or until we resume deliberations tomorrow. So a quick recess so you all can come up here, go through all the evidence, the verdict forms, and the charging document. Quick recess for 5 minutes. And then I'll go back on the record when you all are done reviewing that.
I guess we're not going to see a juror beat over the head today. Oh, that's real disappointing. Well, stroke me in the morning and walk away. I mean, come on, man. I was expecting something and no, nothing. So, I don't know what's happening there. Well, I don't really want to see defenses. Okay, let's just take a straw poll in the chat. How many people want to stay tuned into this so we can hear whatever stuff is going on here and possibly hear defenses 20-minute remaining of their closing? How many people want to see that? And how many people want to go to cop being unmasked? So more defense cowbell or unmasking. What's your pleasure? Close it down? Yeah. Yeah, I think we're done with this. I think we're done with this. Let's go to this morning's thing and watch unmasking because that sounds hilarious. Ninja unmasking sounds a lot more interesting. So let me figure out where the hell that is. Let's see if we can find it in Long Crimes feed from this morning.
How this might get along, they might not get along.
Okay, so in terms of the amount of time or resources that you put into a gang investigation, how long does it take?
And welcome back to Law and Crime, everybody. So we're waiting for day.
You're saying it's on a cash app?
So, yeah,
I guess so. I did my best to keep things clean. I guess I missed that one. Witnesses on the stand.
Yes, Counsel. Now, your objection is was previously stated.
Little things might change from one text to another.
All right, I think I found the moment in the feed. Where they start discussing this Cash App thing. So let's see what's going on here. All right, hold on.
But for the most part, I believe it's pretty much almost the same.
Okay, going to the next message on October 24th.
Excuse me, pardon. Can we approach?
I like the red banner on that. Long crime. Showing some. I like that. That's nice. Yeah, this is the same officer that was apparently masked in the case we just watched.
Just put your notepad down, please don't discuss the case, don't form any opinion about the case, don't allow anyone to discuss the case with you. Thank you. Thank you. Let the record reflect the jury stepped out. Counsel remain on with the defendant and the witnesses on the stand. Yes, counsel. Now, your objection was previously stated as you're objecting to this witness testifying wearing a mask. Based upon his testimony, I overruled the objection, and now you're suggesting you want to revisit that?
Yes, sir.
So go ahead and tell me, make your argument.
May I inquire from the witness?
Sure.
Sir, are you aware that your picture, along with your family, is on the internet as we sit here today?
Nope.
May I approach?
You may. Same thing you showed counsel Seibel?
Yes.
Thank you. Go ahead.
May I show you what is a picture of mask? That is you and your family?
Yes, sir.
And that's on your wife's Cash App?
Yes, sir.
Which is available to anyone who runs that, because we just ran it this morning.
I guess so. I did my best to keep things clean. I guess I missed that one.
We would object to him continuing to testify with his mask on based upon that as public record.
Your Honor, this is nothing that this witness put on. It was something that was done by a family member that he was unaware of. So based on that, Your Honor, the testimony is still truthful and accurate as to what he has done to protect his identity on that. So based on that particular item, I don't think that rises to that level.
Thank you. All right. Detective, can you step down for a second? Just wait outside.
Yes, sir. Your Honor, I have a request.
Yes.
Can I briefly call my wife and make sure that she scrubs everything that I might have missed?
Sure.
Thank you, sir.
Take a screenshot. Take a
The judge
screenshot.
just asked to have defense counsel not to preserve that because that is something that if it got out, there would be concerns for the safety of the witness on that. It's already been seen by the court and be described as such. But to preserve it or do anything else on that that could lead to the safety issues for this witness would be very troubling.
We have no problem with that.
So that's agreed. All right. So, I'd like to hear what the witnesses finds out from his spouse. I guess my concern is, it's always something we're trying to balance things. The news crew has a right to be here and film what's going on in the courtroom. The defendant has a right of confrontation.
It's probably a very interesting conversation between him and his wife right now.
It's not hard and fast. The witness indicates there's stress on his life, and he's worried about his security of his family. And it's balancing of all those things. So I don't know where this came from or how it was obtained. I don't know how you got a hold of the picture in the first place. You're saying it's on a Cash App?
So yeah, all you have to do, her phone number is listed, and when you put her in Cash App, the picture comes up.
Cash App is what?
So Cash App is similar to Zelle, Venmo, so it's if I want to send you money, or better yet, if you want to send me money, you have a Cash App, you send it to either my phone number or to my email, whatever I have set up. And most people do have pictures there. It is open to the public. Cash App is not one of, with Venmo, you can actually make things private. Cash App does not. So everything you do on Cash App is in the public domain.
Yeah, it seems a little concerning and troubling if they'd be looking at the witness's wife and family with the intent to cause them some sort of harm or to intimidate them in any way.
Well, I resent that, first of all. We have a right to confront the accuser. They made a representation. It turns out to be incorrect. So, quite candidly, I resent any implication that we're trying to put anyone in danger. Quite to the contrary.
Thank you for being recessed. When you want to step out and find out, if he's able to find out that the information will be recessed. You need a restroom break, Mr. Dennis?
Yes, sir.
No? All right.
I know.
Nice. Skip ahead.
The understand falls in regular.
Murder on my mind. Stated and Mr.
Peach from
Family.
Sir, are you aware that your picture went online?
Will you
The witnesses finds out from his confrontation. Typically, it's face to face, but it's not hard and fast. The witness indicates there's stress on his life, and he's worried about his security of his family, and it's balancing of all those things. So I don't know where this came from or how it was obtained. I don't know how you got a hold of the picture in the first place. You're saying it's on a Cash App?
So
My life sometimes, I swear to God.
The book of membership.
Okay. Going to October 26th of 2018 on this, there is a message from Gino to the 9807 phone number. What does it say?
Asking if he's good. So, bro, you good?
Okay.
So I guess we're not going to unmask him. We're not going to unmask him. So there was no unmasking. I thought there was going to be an unmasking. You guys lied to me. You guys deceived me. You said there'd be an unmasking. You're a bad chat. Bad chat. Well, they won't show us his face? Aw. Well, I thought we were going to see his face. You all failed me as a chat. You're all bad chat. You should be ashamed of yourselves. I wanted to believe, and you let me down. Shame. Shame. All right, let's go and see what's going on in the other case. Are they still doing shit over there?
Throughout the entire trial for the following reasons, okay? Again, I placed...
No, they're still on break over there in the other trial. Okay. Well, someone better share his Cash App photo. Some drug dealer's got his Cash App now. All right. Well, I guess we're done today. There's nothing more for us to do. And I'm going to see if my landlord will let me sign another 6 months on my lease, I think. So I'm trying to figure out all this out with moving to Houston, because Nate is moving to Houston, I think this upcoming weekend, or maybe it's the following weekend, but it's pretty soon. My lease runs out in August the 31st. And I'm trying to figure this out with improv, because I'd like to finish the curriculum here. So my current class turns into level 4 on 7/17, and then level 5 on like September 11th, and then 6 weeks after that. So that's October. So that's basically November 1st. That ends. Narrative 2 starts August the 15th. Narrative 3 would start 6 weeks, with 6 weeks from then. So it's like October something. So I need to extend my lease until at least November. So I need another like 3 or 4 months. How far is moving from Austin to Houston? It's about 3 hours. It's a pretty serious hike between Austin and Houston. It's about a 3-hour drive. Depending on which part of Houston you're talking about. 3 hours to like central, well, the most western downtown, because it's got 3 downtowns, but yeah. I could also extend month to month, but the month to month penalty is pretty high. I forget what it is, but it's pretty extensive. So I could extend on month to month, but it'd be pretty expensive. Too much stuff going on. I think I'll just sign another 6 months. That would put me September, October, November, December, January, February. So I'd be moving out of here at the end of February, beginning of March. That would put me close to Attorney Tom. Attorney Tom lives in Houston. So Nate moving to Houston means 3 of us are living in Houston. So that's sort of the idea. We'd have 3 of us living in Houston, which would allow for synergy and stuff. Yeah, Texas is the size of France plus about 10%. So Texas is pretty big. I need to talk to Nate. Maybe I'll call him. You can't talk to me? You can't see me? You can see me fine. Yeah. God damn, I hate this stuff. They'll probably make me pay a premium on the 6-month lease too. Yeah, New York, Nate. Nate the lawyer. Nate the lawyer's moving to Houston. Cooler temperatures to move to. Yeah, all right. I'll sign in there 6 months. I'll sign in there 6 months and finish out my classes here, I think. I gotta go talk to my landlords. Let's see if they'll let me sign 6 months without a premium today. I hate my life. I don't know if Nate will need to take the bar or not. He might have to take the bar. Yeah, he might have to take the bar in Texas. Live stream haggling with my landlord. Lord. Texas is only 280,000 square miles. It's not large. Okay. Hey Google, what is the area of Texas? $270. No, thank you. All right, I gotta sign off and I gotta go contemplate my life. I'm not sure if I'm gonna make it to the gym today. I have improv at 7. I've got 3 hours. Ever get sworn in Texas? Yeah, I got sworn in Texas. Got my Texas licensure. Got it in December. Sure did. All right, I'm gonna sign off for now. I'll talk to you guys later. Bye.